Your Lordship, please keep time, then again mention, because my urgency is, I am coming against the inaction of the advanced ruling authority.
It is hearing matter or
No. It is the new motion matter. My problem is, if it is not, they have not disposed of the matter, then I would be unable to file my incorrect return. Correct return, sorry.
Didi, you have mentioned your grounds of urgency.
Yes.
Please mention it and give it. I'm able to remember.
Yes,
Yesterday, many mentionings were made. None of the slips contained grounds of urgency. I do not remember what is being said by what. Correct it.
This matter, my lord, for order. This matter was taken up by the earlier coordinator, my lord, a new motion matter. Very short point. That's why his lordship was of the opinion no affidavit is required. It's a point of law. I'm putting it forward. I'll pass the order. But the difficulty is, my lord, order in original was challenged in view of the order of the earlier coordinate bench. Earlier coordinate bench gave a concession, give a clear indication what is the payment is to be made in order to get the appeal registered. According to the payment made, registry accepted it, registry verified.
You mentioned your grounds of urgency.
Upgradation for upgradation, my lord, rejection of a appeal on grounds of delay. My lord, short point. It is in the list because, my lord, it was in the list. Now it is going down in the list. It will not take more than 2 minutes. I will come with.
Taken up. No upgradation.
My lord, 216, my lord.
Give.
It's a new motion, my lord.
For the same matter, Your Lordship, there is urgency in the matter that the department has initiated proceedings to make open and inspect the items which were seized by the income tax department.
Please write the grounds of urgency. কালকে বা পরশুদিন দেখে একটা urgent
tomorrow
একটা heading দিয়ে তুলে দিন.
We would request tomorrow because my lord, on 13th they proposed to break open the lock. We filed the writ petition yesterday. We've served it, Your Lordship. So, my lord, we humbly bring up it may be listed tomorrow, Your Lordship, because 13th is the date, Your Lordship.
I'll try to get
Friday after 5:30 they have served the notice.
And on Monday we filed the writ.
Your Lordship, may I have your...
You have mentioned the grounds.
We have.
And also the notice.
Please give notice to your other side.
We will.
Once again will serve.
Your Lordship, may I have your Lordship's client leave to mention a matter for upgradation, Your Lordship. Your Lordship, this is item number 173. An order has been passed against me without giving me an opportunity for hearing. Your Lordship, this is an adjudication order. My time period for filing an appeal will lapse. Your Lordship, when this order was passed, I was neither served with a personal hearing notice nor was I given any opportunity. Your Lordship knows that if any adverse order is passed against me, I should duly be given an opportunity for personal hearing, Your Lordship. Your Lordship, given the urgency of this matter, if
You
this
did
could
not
be...
respond to the show cause.
Your Lordships, we've given an adjudication order. So my interest...
There must be a show cause.
Your Lordship, so basically this matter pertains to grant of interest on a sum of money which was paid by me under protest during the investigation proceedings. So, Your Lordship, the deposit has been refunded to me. However, they've not given me the interest. While passing this order...
There's no
Lordship.
here.
In the government welfare code, 51,000 pensioners will be directly affected. Demand notice of 666 crores has been issued. My lord, I'm kindly praying for inclusion.
Inclusion, please give all the matters. Don't mention. Inclusion, please.
My lord, yesterday also I applied for this thing. Mentioned.
Didi ওনার ওই to be mentioned এ আসছে না কেন? ওনার correction এর জন্য কালকে mention করছি। সেটা আমাকে বলুন তাহলে যে পাঠাচ্ছেন কে পাঠাচ্ছে না ফাইল ডাকুন ওনাকে ডাকুন কেন ফাইল পাঠাবে না আমি বলে দেবো যে মেনশন ম্যাটার হিসেবে অ্যাপিয়ার করবে ওরা ফাইল পাঠাবে না ডাকুন নিন কালকে যেন থাকে ওটা কারেক্ট ম্যাটার গুলো কেন দেরি
May I be permitted to mention this matter is running under item number 175, Your Lordship. Urgency is that my lord, my ST number has been cancelled for due to non-filing of my return for the consecutive period of 6 months. But I'm praying to Your Lordship that I am not getting any.
You mentioned your grounds of urgency. Please give.
Kindly.
Your Lordship, may be permitted to mention two matters, Your Lordship.
Yesterday you mentioned. You have mentioned your grounds of urgency because yesterday I found a bunch of slips. No grounds of urgency mentioned.
No, Your Lordship, in both the matters, the notice has been issued. In one matter,
please mention it and give it.
It has been mentioned, Your Lordship.
Very well. Hearing you give, let the file come, it will appear in the list.
May I permit to mention my restoration?
Yes.
My lord, all political scheduled for today, my lord. Well, the matter was also mentioned yesterday, however, it is not available.
লিস্টে আসছে না কোনো দিন,
They have mentioned this matter previously also.
লিস্টে আসছে না কেন? লিস্টে দিয়ে দিন, it will appear in the list. কে ফাইল দিচ্ছে না ওনাকে ডাকুন, যে ফাইল দিচ্ছে না, যে লিস্ট করছে না, দুজনকেই ডাকুন, একটু কথা বলি কি ব্যাপার ওনাদের ফাইল আমরা কি লিস্ট করাতে পারবো না ম্যাটার, যেহেতু ওনাদের
Agency also, my lord.
and I have flagged the copy to the
So 5 identical matters,
Yes.
my lord.
Not hearing.
Owing to this
Deeply obliged.
determination change of determination, the matter has come before your lordship. Okay, so it was earlier there in the court number 17.
17.
Yes, my lord.
Before
the-
17
Before the Honorable Justice Basu, Vishwajit Basu.
unauthorized occupants act. Unauthorized occupants.
Yes, my lord. Grateful, my lord.
Call করুন।
Withdrawn, my lord, as request.
You have brought your letter of instruction from the petitioner.
Over
I have
telephone,
said
I have received, my lord.
you, if you don't bring, I'll dismiss it for default. You bring your letter, I'll keep that on record and then I'll allow you to withdraw.
Kindly take it day after tomorrow.
It will appear tomorrow again. Bring your letter.
My lord, day after tomorrow, kindly consider, my lord. Day after tomorrow, my lord. So that
Day
in the
after
meantime, I
tomorrow.
shall bring my.
লিখে দিন একটু। Learned advocate. লিখে নিন। না না পিএস ওখানে বসে লিখে নিন, তো বেশি কিছু নেই।
My lord,
Yes,
I'm
Mr.
saying
Dev.
apology, my lord, because I was outside Kolkata for a period of 1 month.
No, no, not a
That is
problem.
why, my lord, I was not present before your lordship. Very short matter, my lord, I am not present. Fact is that I was engaged as a daily worker under the forest department.
Yes, I have seen it. Monies are deposited in your account, then they are
Yes,
withdrawn.
this
You are
is the-
given cash.
my lord, this is the-
More than your entitlement is being deposited. They are not giving you check. That is your
Yes.
problem.
Even my lord,
The other
and my
side
lord,
needs
I
to
am
be there.
entitled only 6,000. They have issued 90,000, 70,000. As a result, my lord, the bank authority and income tax department, my lord, they harassed me. So your lordship can dispose of the matter, direct the
No,
CFO.
but it has to be in their presence. No, you serve all them. All of them you serve. Affidavit of service filed today be kept with the record. ওই দিদি ওই অর্ডারটাই লিখে নেবেন।
Filing today my fresh wakalatnama by obtaining
File it in the department. You have to file it in the department.
Lordship.
What is your grievance?
Lordship, as I said, I just received the instruction to appear it today, another day, so that I can.
But somehow when the order came out, it
I'll record. ওই সেম অর্ডার দিদি নানা পিএস দিদি এটাতে সেম অর্ডার হবে 6 ইয়েস
Four, I am appearing on behalf of the respondent, my lord. Four, item number 4, dismissed for default, my lord.
ওনার নামটা তাহলে রেকর্ড করে দেবেন তাহলে নানা পিএস প্রতি পার্টিজ হবে না
এটা তো ফার্স্ট মামলাটা এটা তো ইয়ে হয়েছে ট্যাপ
I am appearing for the petition is arising out of an adjudication order, thereafter appeal, and is the writ petition. Adjudication order, thereafter appeal, and now the writ petition. The main grievance is that in appeal, the proper opportunity of being heard has not been given.
No, but the matter was adjourned on 2 occasions at your instance.
No, my lord, kindly come to page 457, my lord, part 2, volume 2 of the petition.
457.
457, page 457.
Yes.
My lord, kindly see brief facts. Number 1, brief facts. My lord, in the first, second, third,
Fourth, as the appeal petition was filed in compliance with section 1071 and section 1076 of the Act, the same was admitted, etc., 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 and notice was issued on 17/11/2023. Notice for personal hearing was issued on 17/11/2023 on fixed on 12/12/2023. Thereafter, notice of adjournment was issued asking for appellant to appear on 24/9/2024 and 27/9/2024. My lord, as per the 10713, there is a period of 1 year to complete the appeal. So that in the flag end of the period, they have issued the notice. We have not taken adjournment on that date. We have prepared on that date with the matter in 12/12/2023. The officer told he has transferred. New officer will taking the charge. The matter will be taken by him or her. But thereafter, in the flag end of the period, they have given the notice, and the officer, the respondent authority did not want to hear out the matter properly. On 27, there is no practical hearing. Some documents were sought for, that has been given.
No, but these adjournments on 24/9 and 27/9, were they not granted because of your prayer?
No, my lord, we have given all the documents, my lord. On the if you see, my lord, if you
no, but I have seen, kindly see page 367.
Yes, my lord.
Kindly see the first line. On perusal of the application, personal hearing proceeding in respect of the appeal is adjourned. That this means that there was an application for adjournment.
No, my lord, we have not filed any adjournment. On the other hand, we have produced all the documents, my lord. We have produced all the documents, my lord. If you see volume 1,
Mr. Chakravarti, what is this?
This is a factual. Then I have to seek instructions.
Take instructions, come back, whether it was adjourned at his instance or your instance. And if it was adjourned at your instance, then why should they not get an opportunity?
According to the 25 5, 3 adjournment can be given.
We are not on the point of
No, but
adjournment.
they say that they never sought for adjournment. It was the authority who kept on adjourning the matter, and thereafter they decided.
Because my lord, what I find is the appellant appeared.
Where is the time limit of 1 year?
Time limit of 107 sub-rule 13, subsection 13. 107 subsection 13. They have given up in the flag end of the
Where it is possible, it is not mandatory.
It is not mandatory. That's why I am also on that point. It is not mandatory. They can give the hearing. They have not even given me the chance to give the written notes. And I will show my lord how officer will not apply his mind because of the hasty decision, taking hasty decision. I will show point by point.
Mr. Chakravarti, take instruction on this. Likhe nahi. This writ petition assails
My lord, I am for the petitioner.
Other side?
This is affidavit of service. My lord, I am come before this honorable court against the appeal order dated 20 to 25. This appeal order was rejected, not taking the submissions of the learned advocate who was present at the time of hearing. Totally, they have not given the any chance. They have not given anything to. We have given everything to clarify why this. What is the wrong in the education orders? Main contention is that they have appeal order. We have where contention.
This matter is factual, isn't it?
Yeah, factual, my lord.
So
That is.
So I am admitting the writ petition. Let them file their affidavit in opposition.
Obligation. And my lord, kindly grant the stay on the order.
Then 10% deposit. This writ petition takes आप बार-बार आपने उठते हैं What happened? Likheni, none appears for the petitioner. Full stop. The respondents are represented. Yes, it was. It was the earlier one, not this one. 9, item 9.
This is not very. No, item number 9.
আচ্ছা একটু 9টা দিন তো দিদি এই অ্যাফিডেভিট অফ সার্ভিস গুলো আগের ম্যাটারে সব এখানে রয়ে যাচ্ছে একবার দেখুন কেপি ওই 8 বোধহয় আইটেম 8 আইটেম 9টা একটু দিন তো
First day matter kept it for.
ইয়েস এটা আবার ফর ডিসমিসালে দিয়ে দিন এবার নো অ্যাডজর্নমেন্ট উইল বি গ্রান্টেড under the heading for dismissal 24th under the heading for dismissal any yes 10
Lordship, I am appearing on behalf of the plaintiff. Lord, this writ petition is basically to challenge the show cause notice and the order in original, wherein multiple financial years have been included at the time of issuance of the show cause notice. Apart from there, that other issues are also there. My lord, I have been told that this particular issue, my lord, was kept for day after tomorrow, where probably learned senior Mr. Mojumdar is appearing. Maybe kept on that day. As my lord.
you are there
We are there, but the central is the matter. Clubbing central does it. State doesn't normally do it.
Yes, ma'am.
who is appearing for the central authorities you are there
This is the order, the previous order, and my lord, the affidavit of service also it may be recorded.
affidavit of service
Yes, my lord, this is an affidavit. I have to cross the bar of alternate remedy.
no not this one there was an order passed by Justice Rajabasu Chaudhary where he has refused to yes where he has refused to he has refused to interfere because Yes, I was shown this order on the last occasion. So why should I not follow suit?
Lord, my only prayer is, Lord, this is a legal ground which we are raising at this stage, Lord. Though
The
it
same
was-
ground was raised here also.
Yes.
Then covered unnecessarily by
Much.
Nee. The writ petition assails and
Lordship, simplest of the matter, but first the technical part, Lordship. I have made a delay of 250 days in filing the appeal petition. So my appeal petition has been barred by limitation. Thing is that, Lordship, I'm a partnership concern and the senior partner has been diagnosed with cancer since 2024 and he has to be continuously shifted from one premier hospital to another. I have affixed the medical document, page number 50 to 54, Lordship. Kindly have a look, Lordship.
Page number?
Page number 50 to 54, I have affixed all the medical documents, Lordship.
Yes. Yes.
He is currently being treated at the Tata Medical Center at the Rajarhat, Lordship. So
How many partners are there?
Lordship?
How many partners are there in the firm? 2 partners.
He is a senior partner, Lordship.
Where is the case made out that he is the senior partner?
No, Lordship, that I cannot show right now, Lordship, but I have been told that he is a senior partner, Lordship.
He is the managing partner. He decides everything.
He decides everything.
Because the appellate authority has found that you have been continuing with business. All the other operations of the company are merely
business can
going
be
on.
continued, Lordship. My submission is this: business can be continued, but regarding legal matters, Lordship, regarding
Legal
filing
matters, if it was a consultant, yes, but the partner will only have to hand it over to the consultant. Why is the consultant not there?
I cannot improve on this situation,
250 days is too much.
Lordship, my Lordship has condemned 196 days of delay just the previous.
There was ground for that.
That was also medical ground, Lordship.
Medical ground, not for partner. It was a proprietorship firm. I remember my cases.
I pray before my Lordship that this may be condemned, Lordship.
And the wife of the proprietor was ill. That was the ground. Here there are 2 partners, and there the authority had passed a one-line order.
And the subject matter is very
Insufficient.
simple, Lordship.
Here he has dealt with it.
His subject matter is also very simple, Lordship. It is regarding the new instruction of section.
Yes, Mr. Chakravarti.
The reason whether the appeal has also been filed by some other party. It's not,
Then
that is also recorded. But I'll leave it to the cancer patient at the end.
I pray before my Lordship this may be condemned, Lordship.
what is the amount?
I think around 13 lakh. Page number, Lordship, DRC has been given in page number 31, Lordship. Page number 33, Lordship, rather. The last page. One submission is the subject matter is so simple. Had section 16.5 been included at that relevant point of time, this matter would never have appeared, Lordship. This is the case of section 16, subsection 5, Lordship. I could not file my GST 3B, Lordship. Later, I filed that all within the stipulated period, within 30th November 2021, Lordship. So it was just a procedural lapse.
That will require physical ascertainment, factual ascertainment.
Page number 5, Lordship, page number 5.
Writ court, as a writ court, I will not be able to go, when did you file? Because these are all factual questions. If it was a legal question, I could have decided. But it will be best, be to leave it on the authority concerned to decide. I will condone the delay, pay some costs. 200, more than 200, 250 days is too much. Pay costs.
which is issued by the external officer instead of this or in the side excess of this case. This one has got state.
That issue has not yet been resolved.
Pending.
Confirmed means SLP dismissed. That is not confirmation. No, no. Unless those cases, hexaware and all which have been there, those if they are decided, only then you can say that. SLP dismissed will not result in merger. Without notice, if it is dismissed, it is Supreme Court's several judgments are there.
It's like this. May I have a look? What is like this?
Be
that as it may, my lord.
That is understood. Very well, then same order will be passed, Mr. दीदी लिखे नहीं the petitioner এটাও রেখে দিন, এটা দিয়ে দেবেন ফাইলটা।
Lord, I'm just informed that the service has not been completed. So we had served to the department, but now I figured out we have to serve to the GP office. We'll do that. We'll come back tomorrow.
Tomorrow, tomorrow or day after?
But tomorrow, what I have seen, my lord, the appellate order, appeal order has been passed. Possibly, there has to.
My lord, it will be mercy jurisdiction. I'll be very honest.
Why?
Limitation, 120 days delay, 107 appeal. So I will be indicating my
Tomorrow,
case.
not today.
Aja, day after tomorrow. Day after.
Not
Day
today, not today, আগেরটাও not today,
my lord, let it,
13 not today.
my lord, let it appear
Huh?
day after tomorrow. My lord, let it appear day after tomorrow.
12 and 13 not today. Why day after tomorrow? Not, you will not be there
No,
tomorrow?
no, I will be serving. My learned friend may not be there. Oh, Xerox করে দিতে কতক্ষণ লাগে? We'll do it tomorrow. Much okay.
This is the matter pertaining to refund of excess deduction of rupees 2,24,822 along with accrued interest to the petitioner. Now, my lord, out of my claim of 2,24,822, they have already refunded, my lord, 1,75,064 after filing of this writ application. Now, my lord, the deficit amount is, my lord, 49,852 plus interest and along with litigation cost. This is my only prayer.
My instruction also, we have already refunded 1,75,000. But in respect of assessment, they are 6-7, where the refund is due, they have to produce certain documents. We are asking them, but they are not producing those. My instruction is that there are several years assessment years refund are there, out of which all the assessment years refund we have paid. But in respect of assessment year 6-7, certain documents are required.
And this refund you are seeking in respect of which year?
Millet from 2006 to 2000, millet, I have given a flow chart. Millet, from millet, I will give you one.
But after filing of
Just a minute, let him complete once. Yes.
2006, 2007, thereafter 2000.
Which page are you reading?
Millet, internal page 4. Millet, the flow chart is at page 6. Kindly have a look at page 6 once.
6. Yes.
The flow chart. 2006, 2007, 2007, 2008. 2008, 2009, 2009.
So you are claiming 2,24,000 and odd. And what is this interest sum?
The interest is, calculate interest.
No, you have written 4,730. That is why I'm asking you.
But that is in respect of, only in respect of 6 and 7.
So you are claiming this amount also?
Other interest, yes.
No, along with other interest, I could not understand. There is an interest of 4,370 asked for in respect of 2006-7. So far as the other years are concerned?
So far, other years are concerned, then I have to calculate.
You have already filed your writ petition, sir. Those are blank. So you have claimed interest only in respect of 6-7.
6-7.
And this is in addition to this 2,24,822.
Out of 2,24,822, that they have already paid 1,75,000 and 664. Now, in respect of deficit amount,
where is that you have already received?
No, after
filing
filing of this writ application, they have paid.
Acha. And what about the balance?
49,852.
Balance in respect to assessment year 6-7, my lord. For that, my lord, we need some documents from them, my lord. So, my lord, they have to cooperate us. We'll pay, but certain documents are required. We don't have the relevant documents with us. So they have to, my lord. That is my written instruction, my lord. Otherwise, my lord, may I be show me? But in my that instruction is not with me, my lord. The amount which we have already paid, that is there with me, my lord. But he over telephone, my lord, he said, my instruction is that, but the officer said, my lord,
bring that instruction.
I'll written instruction. I'll bring. Yes. No, day after tomorrow, lordship, kindly, I'll bring it.
Likheni. The petitioner submits now this writ petition.
I am grateful. Grateful.
দিদি দিদি এসিটা খুব ঠান্ডা
Here in this petition, I have challenged the impugned so cause notice order in original as well. Because of violation of
order in original and
sorry,
show cause notice and order in original you have challenged.
Yes.
So why have you not preferred appeal?
I am telling.
It is an appealable order.
Lordship, on 21/7/2025, a mail was received from the Assistant Commissioner of Revenue, State Tax, Alipur.
Page
7.
Page 7.
In my petition.
No, that is your pleading. Where is the document?
Okay.
All right, you place in your own way. I will not disturb you. Please.
On 21/7/2025, a mail was received from the Assistant Commissioner requiring payment of demand in respect of the period 1920. In response of the said mail, I had forwarded appeal petition stating that I have filed appeal for the respective period. Thereafter, the response on 8/8/2025 that the appeal petition which I had forwarded is not related to the impugned demand they are seeking for recovery. Then I look into the portal and found that they are correct. I have not filed. But the order related to 1920 has already been issued in this. So my challenge here is the effective opportunity of personal hearing was not provided.
Effective opportunity by the adjudicating authority?
Yes.
How?
The impugned order has been adjudicated after granting a personal hearing only through the GST portal. Though such electronic intimation may amount to service of notice. Once the adjudicating authority observed that no response was forthcoming, it was incumbent upon the officer to resort the alternative mode of service, as envisaged under Section 169 of the GST Act. Such a service by registered post or by affixing the place of business,
No, but
particularly
you
when
said
the
that you
demand
appeared, isn't it? You appeared before the appellate authority, before the adjudicating authority.
No, I have no knowledge about this proceeding.
Yes, Mr. Chakraborty.
Kindly
Respond.
come to page 53.
Respond to this.
Yes, madam. Kindly come to page 53.
Page
53.
53.
The detailed adjudication.
Yes.
At the last paragraph, RTP did not give any answer. RTP was called on the registered mobile number on 3rd April 2024 and was apprised about the adjudication case. RTP did not file any reply. There is no averment in the writ petition. This statement is incorrect.
May I submit?
And reminder and all this was given how? By mail or by uploading on the portal?
Must be uploaded on the portal. The instruction.
Yes, sir. And what did you say that you had? You found that it was not filed. You preferred appeal against this order.
I have no knowledge about this proceeding.
Just now you said you had filed something, then you found that what is that? I couldn't get it.
There are two orders in respect of same period, and same issue is covered.
Where is the first order? If there are two orders, show me one by one.
First order is from page 49 to 54.
49. This is summary of order.
Yes.
52. 54, yes. And where is second order?
Second order is on page 57 to 60.
57. What is this, Mr. Chakravarti?
But this is my lord would find there is no tax component in the next order, page 57.
Yes.
Yes. Well, this was on, when it appears, well, this was on a different issue at all. And in the order impugned before my lord, there are other components, tax, penalty, all that. So well, there may be other proceedings also.
How can there be two proceedings in respect of the same year?
There is no subject to correction. There is no bar, my lord. Subject to correction, my lord, there is no bar. It my lord sees the language of for different cause of action. There can be two show cause notices, and it appears, my lord, in 58.
No, but
my lord,
interest cannot be a different cause of action. Interest is a component
Well,
of the main.
interest, maybe he has paid something, but he did not pay the interest. Like after DRC 01A, yesterday, my lord, I had shown if after DRC 01A, he has admitted some liability and paid, but he did not pay the interest component. It appears, my lord, this is that case, and it would appear, my lord, this is going to the next page 7512.
Let's say, may I submit?
Just a minute. Just a minute.
Let's say page 53 will clarify all the things.
Page 52.
53.
Yes.
Lordship, I have not participated in any proceedings in this petition, but the authority has deleted my demand. Some proceeding has been they have initiated, and the interest is respect of.
My lord, I'll tell you, my lord, this was done page 59. It is under 7512. Because the same officer, if my lord finds the Shangukta Ghosh, this is a proceedings under 7512.
Yes.
Kindly see the, my lord, the language of start with the non-obstante clause 7512. Notwithstanding anything contained in section 73 or section 74, where any amount of self-assessed tax in accordance with a return furnished under section 39 remains unpaid either wholly or partly, or even any amount of interest payable on such tax remains unpaid, the same shall be recovered under the provisions of section 79. So, when
Yes, so this is a different proceeding.
Lordship, I am not on issue that two so-called two order cannot be issued. I am showing that the matter has already been dealt with. If you come to page 53, point number 5, interest payable.
Yes.
This is revised recalculated interest.
Page 55.
53.
53 interest payable
53.5.
where? Interest payable, yes.
Yes.
Lordship, kindly refer to page 54.
54.
RTP was given reminder on 26 and asked to appear for personal hearing and asked to file. Neither appear nor file any reconciliation. Hence, the interest and penalty as under determined.
So why are you not preferring appeal against this order? I fail to understand. This is an appealable order. Why writ petition should be
There is no
entertained?
appeal is required till now.
Why?
Mm,
Where is the jurisdictional error for the writ court to intervene at the adjudication stage? Why?
Lordship, I am submitting.
And why have you come up after 1 year? The order was passed on
9th August 2020.
yes.
Lordship, this came to my knowledge on 21/7/2005. Immediately, I have replied to mail.
Where have you written that in your writ petition?
page 7.9.
Page 7.
This recovery notice was sent through mail.
So what? So you could have then challenged it by way of an appeal. Why writ petition? Why should I entertain a writ?
Sir, Lordship, my present demand is related to ineligible input credit, which has retrospective.
Very well, whatever it may be related to, the authority had jurisdiction to pass the order. It's an order within jurisdiction. Why writ court should intervene?
By amendment in section 16, my credit is well eligible since I have filed return.
Sir, eligibility or non-eligibility is a factual dispute which will be decided by the appellate authority, by the adjudicating authority.
Lordship,
How writ court should?
This has been retrospectively amended. It is my vested right to get.
So you get it before the appellate authority. Why writ court?
There is no pre-deposit is required since I am eligible. I am showing when I have filed return.
So you file the appeal first, then question of pre-deposit or non-pre-deposit will come. You have not filed the appeal. You have challenged the adjudication order in writ petition. That too after 1 year.
Lordship, kindly submit then. I am on effective opportunity of personal hearing. In this respect, I have relied.
No, don't rely on judgments. That I know, that if personal hearing has not been granted, there is violation of principles of natural justice. I can intervene, but you have not been able to satisfy that it was not granted.
I have submitting effective notice has to be sent.
If they have called you over phone, they have put it on the portal, you have not denied it in the writ petition, how will I presume that no notice was given to you?
Lordship, they have sent mail.
Mail for recovery.
They have called me over phone. There is no evidence.
You have not denied that. That is a part of the order. That is the order you are challenging. So where have you denied that? In the writ petition that is false?
I have not denied.
Then if you have not denied, you have accepted. You have to give some handle to the writ court to intervene.
But through call cannot be a service of notice.
Why not?
It may be on SMS.
Why not? Why not? What is the purpose of notice? What is the purpose of the notice? The purpose of notice is to make you to put you on to make you alert that yes, a hearing is going to be taken. You have that knowledge.
169 does not say so. The call
169 says about portal. Then portal is there. So portal is there. They have gone ahead, given you a phone call also.
If they certainly uploaded certain thing on the portal, if it does not come to my knowledge, how can
it came to your knowledge by way of the phone call?
No, by way of no phone, by way of mail, I immediately have respond. Previous notice,
they are not obliged to give you everything on mail. If they have put it on portal, it was your duty till such time the act is amended.
It will be just formality then.
That is up to you to get the law amended.
I am
such time we'll have to abide by it.
I am certainly submitting some case law that effective opportunity has to be given.
Show me.
Our court has held just a constitutional issue that portal uploading is a sufficient service.
Yes. If portal uploading is there and there is an SMS alert, then in that case it's there. Here there is a phone call also.
There was a one contradictory judgment where it said you have to email also. Interpreting that's not a good law. Under that, our court has held.
Lordship, I am not submitting of notice, or I am effective opportunity of personal hearing.
It is effective. If it is there on the portal and you have received a phone call, then it is sufficient.
I have referred Lordship Madras High Court goes TVL C Mathuri Israel Traders.
Yes.
I would like to refer point number 7.
Yes, page 7.
Assuming that sending notice by uploading in the portal is sufficient service, when the officer who was sending the repeated reminder received no response from the petitioner, he ought to have applied his or her mind as explored diligently the possibility of sending notice by other modes prescribed in section 169 of the GST Act.
Sir, first ground is that there is an appeal provision. You go before the appellate authority. I have read this judgment. Any other judgment you have, please don't waste time unnecessarily.
Lordship, I would also like to submit that it is 73 has prescribed 3 months to after 3 month order can be issued. It has been issued before 3 months. This is also jurisdictional issue.
It doesn't say that it can't be before 3 months.
Outer limit is 3.
Hmm.
Lordship,
That is
Now
period of limitation. It is not the period of.
this order is also barred by limitation.
No, there have been extensions, subsequent extensions.
Lordship, is extension has been held constitutionally invalid.
Not by this court.
No, Lordship.
Then I'm not bound by any other orders.
Lordship, then my last argument is the demand pertains to this order is related to ineligible input tax credit. By virtue of
That is
amendment,
on merits. I will not interfere with an adjudicating order on merit. You have the appellate forum.
kindly submit.
No, appellate forum you approach. Why unnecessarily you are inviting merits?
Lordship, I am eligible for credit.
That appellate authority will decide what is the purpose of having an appellate forum if everything has to be decided by the appeal court merely because you want to.
I just praying lower authority may verify and allow since it has been amended.
It has to go before the appellate authority, sir. Approach the appellate authority. Your only purpose of filing the writ petition is to obviate the delay that you have occasioned. You could have approached the appellate authority. After 1 year, you are coming here. There is no explanation.
Lordship, I just when I have received the mail, I have.
Your receiving the mail will not do. If you had made out a case even of uploading on a portal in a different tab, there are cases which have come to the court and the court has ruled in a particular manner.
Lordship, if 16.5 is considered, there can be no demand.
You appear before the appellate authority. Appear before
it
the.
has to be forced to be pay deposit.
Have you challenged the notifications? That also you have not done.
Yes, challenge.
Where? If you could have challenged the notifications, that could have given some respite to you. Notifications are also not
56.
challenged. Huh?
Notification 56.
I don't remember the number. Show me in the prayer that you have challenged.
Lordship,
One is, I think, July
page number
2022 and March 31,
Page number
2023.
Page number 10.15.
Page 10.
But he has, if, prayer if. But then center has to be made a party, but possibly he has not.
I have also referred state jurisdiction, state notification also.
Yes, you have prayed.
Yes, sir.
That he has prayed.
But then
Very well, I am admitting the writ petition.
the center has to be made a party. He has not made a center.
Yes, center has to be made a party then.
But
Because notification is
Lordship, state also issued same notification.
Well,
This notification is of the Central Board
both
of
state
Indirect
and
Tax.
central has, but they are independent. But
The notification challenge is not of the state but of the center, but then center also has to be made a party. Add them, serve them, come back. As prayed for, leave is granted to the petitioner five minutes.
That's why I'm appearing for the petitioner. Lordship, my lord, I have challenged the appellate order under section 107 and 4, whereby the learned appellate authority rejected the appeal of your petitioner on the ground of limitation without examining the merits of the case. Your Lordship, it is a case of a partnership firm, and your Lordship, the partnership firm have been operated by two senior citizen persons, super senior citizen persons, your Lordship is called to say, 83 years old, and the partners are entirely completely dependent of a person of accountant. The proceeding has when was initiated, he has neither informed the proceeding and outcome the proceeding. Your partner came to aware about the entire proceeding when a telephonic call has been given to by the jurisdictional assessing officer to your partner, one of the partner, Prana Krishna Roy. Then he look after the matter and take initiation in this case and file the appeal of the continuation before the with a maximum delay of 281 days. This is the case, your Lordship.
Where is
And
the
your
explanation?
Lordship, the petitioner has a substantial case, has a merit.
Where is the explanation given? Where
Delay
is
is
the
explanation delay, your Lordship, kindly find the page number 43, followed with the page number 47, your Lordship.
Three.
43 and Lordship, when the so-called notice has been issued on page number 47. Your Lordship, take up the page number 50, where you
Difficult,
find the observations of the appellate authority. Point number
I have
2.9.
I've seen them. There is no explanation. This is
Your
no
Lordship,
explanation.
your Lordship, it is the partnership firm operated by the super senior citizen persons, your Lordships.
So what?
And the consultant, who is the dependent on the consultant, he is neither informed about the issuance of the notice and neither the outcome of the proceeding. Your Lordship, your petitioner is came to aware about the entire proceeding when the judicial assessing officer make a call for recovery of demand.
What is the demand?
Demand is 3,16,000. Your Lordship, very nominal demand.
Yes, Mr. Chakravarti.
And it is the substantial merit of the case, your Lordship. You have every chances of get 100% relief.
Explanation is horrible. You should have given some explanation.
Accountant, no name is there.
I will give name if you require.
Cost you'll have to do because these
As your Lordship.
10,000.
As your Lordship.
I am seeking for accommodation, my lord. My lord, it may be fixed, my lord, on 24th with the two matters heard on yesterday, my lord. My lord, for several matters, I need instruction, proper instruction.
It
That's
is
why.
related to the same points are involved or different points?
Mostly same point. Factual
61.
points are different, but legal.
61 point.
Yes, my lord.
That's scrutiny point.
Because the returns were scrutinized. First of all, my lord, if your lordship go through page number 37, the adjudication was done on some Taher Automobiles, the reseller of automobiles. I am not an automobile dealer. I am a jute and paddy dealer, and my legal and trade name both are same, Laltu Dotto. But whose
The appellate authority, what did the appellate authority do with this?
appellate authority done on the basis of adjudication order. So
Mistake.
no, he has done on the basis of adjudication. So whose adjudication has been done? What I need to verify first of all. Thereafter, my lord, verification of returns have been done.
No, you
So
are not Taher Automobiles.
No, I am Laltu
But
Dotto.
adjudication has been done for Taher Automobiles.
It is written over there. Hey, প্রথমেই, the second paragraph.
This was pointed out to the appellate authority.
Probably not. Probably not.
Then
My lord, I am
very well.
noticing. My lord, it may be fixed on 24th, my lord. With the
24th, so many matters will be there, not 24th.
Taher
then
Automobiles.
26.
maybe
26.
my lord.
As prayed for, list this writ petition.
It is instruction also.
Here, this is against an appellate order. My lord, this order rejects my refund, my lord. My lord, I would directly refer to the relevant part of this particular order, my lord, page 178. My lord, it's a very short point, my lord. The point is delay. My lord, the refund application ideally should be filed within 2 years. Now, mine was filed about 36 to 39 days later, my lord. Now, my lord, page 1778, if my lord is pleased to take up, observations of proper officer. This has been, my lord, confirmed by the appellate authority, my lord. From the records available in the back office portal, it appears that the referred application made on 21st of February 2024, VDA number such and such, was withdrawn. My lord, this date, my lord, 21st of February 2024, this was within time, my lord. But some documents were not available with us. We had come to the realization that it will be rejected. So we withdrew it on that very date. On 21st itself, it was filed. On 21st itself, it was withdrawn. But then we refiled it in April of that year, my lord. Now, the reason, my lord, the reason for this delay, my lord, I have explained in page 171. My lord, this is the grounds of appeal, my lord. that why this delay after withdrawal. The very last paragraph of this particular page, my lord. The appellant could have solved the matter within a week, but in the meanwhile, and unfortunately, one of the directors of the company, Mr. Shankarlal Rajgaria, who went through a severe heart attack and a major operation a year ago, got severely ill, and some complications were encountered. Again on 13 February 2024, and was advised rest for at least 1 month for rejoining office. Now, this was the main reason. I have also annexed the medical certificate at page 173. Now, if I may refer to the statute, my lord, page, section 54 is the relevant section, my lord.
এটাই রেখে নিন তো, এটা কোনটাতে আছে ঢুকিয়ে দিন।
My lord,
Section 54.
Section 54, subsection 1, my lord. This provides for the period of 2 years, my lord. And I'm reading it out, my lord. Any person claiming refund of any tax and interest, if any, paid on such tax or any other amount paid by him, may make an application before expiry of 2 years, my lord. I am harping on the use of the word may, my lord. So this makes this particular provision, my lord, directory and not mandatory. And my fact is, my lord, that I had filed the application within the period.
Within 2 years?
Within 2 years, my lord. And then I withdrew it on the very same day. But the refiling took some time. And that also.
And that was beyond 2 years?
That was beyond 2 years. About 39 days, my lord, is my count.
Do you have any authority to show that this is extendable at the instance of the GST authorities?
My lord, the statute itself, my lord, I am relying on that particular point, my lord. I am relying on the statute itself. The use of the word may.
No, may is difficult because it has to be interpreted. Then, if there is an interpretation earlier than this code, then in that case, I will rely on that. If there is none, then I will have to interpret.
My lord, not that I have come across.
This has to be, but I have to also consider there are judgments. There are judgments both ways. There are judgments. I am aware of it. But kindly give me 1 or 2 days. We'll come back and this requires something. This is an important issue which to be decided. If it is not mandatory, because 2 years is the outer, and the relevant date is 14.
They have referred to some notification there. What is that notification?
My lord, here is the notification, my lord. This is, my lord, the exemption of limitation for the COVID period. That notification, my lord.
So your date fell within the COVID period?
Yes, ma'am.
Then that exemption should be available.
No, even after giving that exemption, my lord, it is beyond 2 years.
Oh, achha. Even after that exemption, you are beyond time.
Yes.
The only exemption during the force majeure.
You filed it on which date? Your date is?
My lord, first I filed on 21st of February 2024.
Oh, 2024. Then you withdrew on that date.
On that day itself.
And then when did you file next?
Then, my lord, 6th of April 2024.
And your time to file began when? Started running when?
My lord, according to this particular notification, my lord, I am exempted.
No. When did your time to file it start? When did the limitation set in?
My lord,
2 years began from which date?
The relevant date, my lord, starts from 21.
21.
2021.
Which date? Exact date?
My lord, exact date, my lord. My lord, there are a number of my lord invoices, my lord.
Very well.
So,
very well.
And also the fact
to consider also subsection 14, because the definition of relevant date is there. But that
Subsection 14
of 54.
Of 54.
Subsection 14, subsection 14(2), where what does relevant date means?
Yes.
This has to be considered because this case has to show that which of the provisions this case was.
Very well. The petitioner a sales an order. Yes.
No, my case is very within a very limited and narrow compass. I just want before your lawsuits, you want before the authority again, because certain documents are not given to me. I just take out only those portions your lawsuits.
Natural justice.
Natural.
Natural justice.
Well, kindly take up the volume 2. These under the Customs Act. Well, page 183 is the focus notice.
183.
Now your lawsuits will find my name is 2, Sudhir Kumar Pandey, in
Yes.
the very first notices. Now your lawsuits will find page 187.
Hmm. 187.
I just no, well, I'm sorry, your lawsuits 186.
186.
My lord, second point. Sri Sudhir Kumar Pandey and Sri Anil Kumar Dikshit both had sent him the documents like, matlab, him means your lordships, the statement Chandra Kanto Tripathi, like bills of lading, invoice, packing list, etc. through WhatsApp and requested him to arrange to clear the consignment. Matlab, these WhatsApp messages was the basis of the finding. I will take your lordships to the other pages, page 207. This is so-called notice, of course. I will take your lordships to the final order also. Page 207. Now your lordships will find 4.3.5. Sri Chandrakanta Tripathi was again summoned, dated such and such to appear. Sri Tripathi in his statement dated recorded under section 108 of the Customs Act 1962 inter alia stated that Sri Sudhir Kumar Pandey lied in his statements, and both he and Sri Anil Dikshit had sent him the documents for both Mrs. HON'BLE Enterprise Bhutan and Mrs. Sipsai Medic Enterprise Private Limited Nepal. In support of his claim, that means Malab Tripathi, he had also submitted WhatsApp chats made with Sri Pandey and Sri Dikshit. And then you lost it, page 270. Look, 7.13. WhatsApp chats made with Sri Sudhir Kumar Pandey submitted by Sri Chandrakanta Tripathi unambiguously indicates. Well, this is so-called notice. But as we have learned, your lordships appears to have your lordship. But this is somehow shows me indication of when my mind is already made up.
Closed.
Already. Unambiguously indicates that Sri Pandey was in full control of the consignment from the commencement of the import and had repeatedly dictated Sri Tripathi for processing and clearance of the consignment. It was also seen from the himself sends documents such and such to such a processing. From the WhatsApp charts, it is further repeated. A whole finding, this is one of the, I don't say that this is the only basis. This is the main basis I just tell you. That these are the WhatsApp chats. No, what are the chats? I should know at least. That should be given to me. This has not been annexed to the so-called notice. Your lordship 227, the annexures. I do not find your losses. I will stand corrected by my learned friend if I get it.
And these WhatsApp chat chats form the basis of the order.
Order. That I will take your lordships. Page your lordships 241. In verbatim that has been quoted in all the pages your lordships will find. Only 241. It starts. I will take your lordships some of the pages. Lord, your lordships will find page 244. Second point. This is reproduction of the so-called notice. Completely reproduction of the so-called notice. Page 263 also your losses will find. So all that I'm wanting your losses, let me have a copy and go back to them. After hearing my contention of the chats or that. 293 also your losses will find. Your losses will find 14.2.3 mens rea.
Page 293.
293. The overwhelming,
yes,
the mens rea for the overwhelming consistent evidence, including direct admission by co-notices, irrefutable CDR data. I can make certain submissions in regard to this also, but I think this is not the right stage. Authenticated WhatsApp communications. And his own contrary evasive established a high degree of mens rea. say Sudhir Kumar knowingly conceived. But this I should get, my lord. And on the same page, your lordships will find in the point number 2 from the top.
WhatsApp chats.
WhatsApp chats. And then your lordships, same page, 4.14.2.4, offences. Based on the role, evidence and means we are discussed about. But I have, at this time, I'm conscious of that this is an appealable order, all that. But let me conclude it over them first. Let me exhaust all my points. This is not clear to them. Sometimes we miss it. All are not technically, legally sound, my lord. But miss it. That doesn't mean, my lord, it will happen. I'll give me the copy of that chart, deal with that, and then. That's my only submission.
Yes, Mr. Dey.
My lord, this is an appealable order, and all efforts were given to give them a proper hearing in terms of the principles of natural justice, and all the relied upon documents were submitted to them.
But this is also one of the
during the I shall show to your lordship. During the course of hearing, they have never asked for these documents and these WhatsApp chats. And so far, these WhatsApp chats are concerned, lordship kindly gives me a 2 days time. I shall come back and try to satisfy your lordship that whatever has been done before the forum below has been done in the proper manner.
Very well. Show me that this WhatsApp, because this WhatsApp chat forms the
They are not
basis of the
printed.
order.
I will try to show to your lordship.
If I had have found that the WhatsApp chat has not been taken into consideration while arriving at the final conclusion, then in that case, I would have overridden the objection saying that it has not caused any prejudice. But this looms large because it forms the basis of your observation that it gives rise to mens rea. Mens rea is taken into consideration in arriving at the final conclusion and imputing the guilt to the person concerned. Then in that case, this assumes some importance.
Very well, lordship kindly keeps it.
I have not decided yet, but this is the prima facie observation so that you can also respond to it.
Well, I'm conscious about the
appellate remedy.
The jurisdiction of your lordships and in regard to that's why I'm on a very limited point.
लिखे नहीं this
Well, praying for not today.
Not today.
Lord, I appear on behalf of the petitioner, my lord. Kindly, I pray for an adjournment today, my lord. My senior is, because of some emergency, is not present, my lord.
Not today.
Not today, my lord.
Not today.
Grateful, my lord.
এগুলো নিচে একটু ডেট দিয়ে দেবেন তো, টাইম চাওয়া হয়েছে বলে। হ্যাঁ, 1 বলে লিখে দেবেন, তাহলে মনে হবে যে একবার টাইম চেয়েছে। তাহলে লিস্টের নিচে ব্র্যাকেটে 1 লিখে দেবেন। দিদি, আর ওই যে 19 তারিখ Yes,
My lords, I am for the petitioner. My lord, today come with three basic grievances. 23. So there are basically, my lord, three grievances. First is that the entire process which is started from the show cause notice itself, it's completely violation of principle of natural justice. The order in appeal against which I'm before the Honorable High Court, there is a cryptic order which is not considered any of the considerations that have been given by us. And my lord, it is to be observed that from day one, here the most surprising thing is from the same jurisdiction, Baligan charge, we have received two separate notices within a gap of a few days. And the matter is mainly alleging to whether a taxable event can depend on TCS deduction or not. Just to give you, lords, my background, I am actually a franchisee of cakes. So in this kind of structure that I have as per the agreement, the franchisor, they are supposed to pay the GST on the same, and as the invoice for the same is issued in their name. This is what the infrastructure of the law is. And that is also, I'm supported also by a circular issued by CBIC. So by mistake, what had happened, when I'm supplying this supplies through Swiggy, which is Bundle Technologies, which is properly known as Swiggy, they deducted TCS. As per section 52, they are obliged to deduct a TCS. So I have unknowingly accepted the TCS and utilized that TCS. That is my only fault. But the fact remains that whatever money I've collected from Swiggy for this particular supply, along with the GST, I have deposited with my franchisor. And I also have a declaration, substantive proof. I've given my profit and loss account where my limited amount of commission is shown, which is my only taxable supply. I also have a declaration from my franchisor where he clearly mentions that on this particular supply, I've already discharged the tax. So we have to, here, my lords, I'm mainly to appreciate whether on the same taxable event, when it has been defined by the law, can a tax be again imposed? That is a moot question here. Apart from that, I will take my lords to the show cause notice, where itself they are saying in page 47, my lord. My lords, if we go to the show cause notice, page 47, the proper officer himself is acknowledging on page 48 that what are the documents I have given. And this matter started in February 2021, when I was, as a vigilant taxpayer, I responded.
48 is something else.
No, my lord, page 48 is the, that's a part of the show cause notice.
No.
PK Enterprise.
Page 48. Achha, it's a part of the show.
Part of the show cause. That's what I wanted to bring before my lord. That the proper officer is himself saying that these are the documents submitted by the taxpayer in February 2021. And we are sitting in February 2024 after 3 years. Two charge officers are sending me the summons and notices. I'm responding to both.
So the documents which are enumerated at page 48.
Yes, my lords.
These would have otherwise sufficed for the purpose of the.
Yes, my lord. It's a very simple case. because I am supported by a proper circular in this aspect. The declaration is there, my lords, on page 94. If I may take my lords on page 93 and 94. Yes, my lords. My lords, in my turnover, which I have reflected, that is 17231,260, the second right column. From the right hand side, the second column, total sales. 17,231,260. These are sales affected by me through my franchisor. And if I go to the next page, my lord.
Just a minute.
Yes, my lord.
Yes.
My lords, if I go to the next page, my franchisor has duly supported it through a declaration, if I may read for my lord. In the financial year 1920, sales amount through franchisee, Messrs. PK Enterprise, address such and such, was 1,72,31,260, of which total GST has been paid by us through our GST or 3B return. The commission amount of financial year such and such to Messrs. PK Enterprise is 20% of the total sale, that is 34,46,252, which is also substantiated with my profit and loss account, my lord, which is on page 90. On page 90, I've duly given my commission received.
So what is the problem with the authority now?
My lords, they have just issued the show cause notice and the appellate order in a mechanical manner, not considering that in GST, the main taxable event is a supply. And only on supply can tax be charged. They are taking the view that since the TCS was accepted by me, I have become the supplier. But effectively we have to see
You
that
are only the middleman.
I am the middleman, my lords. And may I take my lords through the circular also for ease of convenience. My lords, may kindly go to para 7. So, my lord, there are two types of situations in which a principal and agent can work. In one, where the principal is billing to the agent and agent is billing to the customer. And in the second, whichever is said in the fourth last line, if I may read for my lord, however, it may be noted, in cases where the invoice is issued by the agent to the customer in the name of the principal, such agent shall not fall within the ambit of Schedule 1 of CGST Act. So what does this mean? This means that it is not a separate supply for the agent. And how am I supported, my lord? I am supported through scenario 2.
You have issued invoices in the name of your principal.
Yes, my lords. That is also given, my lords. That is on page 119.
Cakes.
Yes. That's a brand name. For Square Bakers Confections, the name is also given. Square Bakers Confections Private Limited.
And you are?
I am PK Enterprise, my lord.
Your name is not there.
No, my lord, it's not there. And it's as per the infrastructure or the net or the framework of GST. If I may take my lord to page 3, scenario 2 of the circular just handed over by me, my lord. My lord, may I read? Mrs. XYZ, a banking company, appoints B to auction certain goods. The auctioneer arranges for the auction and identifies the potential bidders. The highest bid is accepted and goods are sold to the highest bidder.
What are you reading?
My lord, sorry, the circular I handed over to you, my lord.
Yes, which page?
Page 3, scenario 2. Page 3, my lord, scenario 2. XYZ, a banking company, appoints Mr. B auctioneer to auction certain goods. The auctioneer arranges for the auction and identifies the potential bidders. The highest bid is accepted and the goods are sold to the highest bidder by XYZ. The invoice for the supply of goods is issued by
Yes, I have got it.
Yes, madam.
Yes, Mr. Chakravarti.
There's an adjudication order which appellate order, there is no. He has just said there is no reason to intervene. So, but that is not. But what I find is he was relying on a document page. that is reproduced in page 135 also.
Yes.
The adjudication order, which the adjudicating authority says it was never uploaded in the portal. And
May know the page.
136.
Yes.
When I would find that letter is at page 135 PS. Observation as per our information at enforcement module of the GST portal, no such document or any order further notice is available in GST portal. As this case ID is transferred from another proper officer to the undersigned, and also any payment is not found in GST portal in respect of the above mode finding was mentioned in the notice based on enforcement module till date. Thus, the undersigned has no option to proceed further. Issue an intimation is also answered.
My lord, I'm not on this because I have not gone on this allegation that I've already given in February 21 to you before 3 years.
It appears that this is a detailed order. What I've understood is that he is not selling, he's just an agent. But he has some transaction with me. Let me come back and see whatever, and come back and we're in a better position to answer to the mind of.
Very good. Where is the appellate order?
Page 167, my lord.
feeling cold because it's on my head. Actually, একবার চালু করে দিন। মাঝখানে বন্ধ করবেন, তারপরে চালু করে দিন, কিছুক্ষণের জন্য বন্ধ করলে আবার ঠিক হয়ে যাবে। এটা একদম মাথায় আছে তো? হ্যাঁ, হবে।
My lord, I'm praying for not today, my lord, in this matter.
Not today.
Kindly keeps it on Thursday, my lord. Kindly keeps it on Thursday if your lordship.
Thursday may be difficult. I'll keep it on Thursday. লিখে নিন। হ্যাঁ, কি অসুবিধা কি আছে? As prayed for.
What I was saying, I have already written
Yes, Mr. Deep.
Well, I am appearing for the petitioner. But here I have challenged the appellate order. I have taken several grounds in my memo of appeal, which goes to the root of the matter. Authority decided only on the merit, my lord, without considering any of my grounds which goes to the root of the matter. What happened, my lord? A so-called notice was issued under section 73 of the GST Act, asking me to file a reply or pay the dues as per the so-called notice. I filed my lord, an application for adjournment that because of my advocate is not present in Calcutta, so you allowed me one adjournment. Without considering my adjournment application, my lord, the authority passed the order. My lord, your lordship knows better than me, my lord, that personal hearing is mandatory, my lord. That was also not given. And my lord, the order passed by the authority is, my lord, totally not cryptic, my lord, non-speaking, my lord. Kindly come to page number, my lord, 40. First, my lord, kindly see the so-called notice, my lord. Your lordship will find page number, my lord, 38. So-called notice starts from page 33. But of so-called notice, your lordship will find page 38. Kindly turn next page, my lord, page 39.
Yes.
In the tabular form, my lord, your lordship will find date of personal hearing NA. So, law requires that if you are contemplating any order affecting the petitioner or the RTP adversely, you have to give a personal hearing. Now, my lord, kindly see my application for adjournment. Page 43. My lord.
Page 43.
Yes.
Yes.
I, my lord, filed an application for adjournment. Our advocate, my lord, so and so is presently out of station. He will be available on such and such. So, our humble request, please allow a short adjournment for 15 days and oblige. Now, my lord, kindly see the order at page 40. My lord. Page 40. 27th December 2023. I filed an application for adjournment on 22nd. Whereas upon examination of the records, books of account and documents furnished by you for the period such and such in course of audit under section 65 of the Act, read with such and such, discrepancy is detected upon such audit was communicated to you as excess claim of input tax credit. The RTP is liable to pay tax equal to excess claim of input tax credit, difference between ITC in GSTR 3B 2A, which is accepted by RTP. Well, wrong point. I never accepted. Well, RTP has made payment voluntarily through TRC 3 on the above ground by debiting a e-credit ledger as under. Therefore, the auditor is liable to pay interest at the rate of 18%. Now, well, thereafter, well, page 41. As per GSTR 2A, the RTP is liable to pay IGST on RCM basis, that is reverse charge mechanism basis. against inward supply to the tune of such and such. Well, there is no, well, the basis based upon which the order was passed me. Just that certain tables were given, and since there is a difference or mismatch, so you are liable to pay tax. So, my lord, this is a non-speaking order. I challenge this order, my lord, in my memo of appeal on several grounds. You will also will find my memo of appeal at page 61 is the grounds of appeal, my lord.
Yes.
Ground number 2 is, my lord, that the notifications issued under section 168A extending the time limit for completion of the proceeding are, my lord, ultravise the act, my lord, itself. Now, second point, my lord, the DRC 1A, that is the pre-show cause notice or
This
intimation.
ground appellate authority will not be able to take into consideration
Well,
because
this-
they will be bound by the notification.
Yes, no, my lord,
So they
page-
can.
ground number 3, the authority can consider, my lord, DRC 1A. I have stated, and I have cited case laws also, my lord, that DRC 1A is, even if it is word may has been used, but when you are using the discretion, my lord, you have to apply your mind, my lord, as to why you are not issuing the DRC 1A, that is the pre-show cause notice, my lord. Now, my lord, kindly see third point, that the order is cryptic, my lord, page ground number 5, my lord. Because the 75(6) says, my lord, that you have to provide the reasons and the basis for the decision you are making, my lord.
What has the appellate authority done?
My lord, thereafter, my lord, appellate authority passed the order, my lord. I appear, my lord, your lordship will find thrice before the appellate authority at page 66, my lord. Kindly see last paragraph, my lord. The appellant filed the appeal petition within the prescribed time under section such and such. Hence, the petition is accepted. APL 02 was issued on 18/4/2024. A notice of personal hearing was issued, fixing the date of hearing on 12 June 2024. Subsequently, 3 adjournments were granted on such and such a date. My lord, I appeared and produced the books of account and as well as the documentary evidence in support of my contest. Now the authority is saying, my lord, that I did not produce any document. My lord, kindly see page 73. After recording all my grounds, my lord, last but second paragraph. During the course of hearing, the learned authorized advocate failed to produce invoices for the inward supplies against the which claim of ITC has been made. The mismatch between GSTR 2A and GSTR 3B for the period under appeal could not be reconciled by the appellant. The claim of the payment of taxes made by the appellant during the adjudication process is not considered. The records are called for, my lord.
But he says he could not produce anything.
My lord, in the course of hearing, my lord, 3 adjournments were granted, my lord, and I have produced the documents as per his wishes, my lord, that these are the statements which you are required to.
Is there any proof of you having produced?
No, my
the
lord, I do
document?
not have, my lord, evidence.
Because if this is the recording, then in that case, how will I believe that it was produced? Maybe documents were not produced.
So then, my lord, I have, my lord, specifically, my lord, stated in paragraph number 11
That
you
becomes
please
a factual thing.
submit and state that the, my lord, if the records are called for, my lord, you will also will, my lord, see whether I have produced or not. Because there must be noting, my lord, which the notings were not provided to us.
Then this has to be decided on affidavits.
Yes, or my lord, one opportunity, because my lord, before the adjudicating authority, I did not get the chance, my lord, to produce the documents because I have specifically prayed for adjournment.
Yes, Mr. Chakraborty.
On page 37, it appears he was asked to come with the documents, but it doesn't. On page 37, my detailed show cause notice, last question, page 37.
But well, that I prayed for an adjournment.
Yes, here he prayed for an adjournment.
26 March.
Audit report.
Subject to correction with this 43 is 22nd December 2023.
Yes.
And my lord, page 39, my lord, the date by which I have to file the reply.
What I am relying on, my lord, would kindly come to page 33.
33.
Show cause notice dated 3rd May 2000. 23, just the below portion, my lord, where so, my lord, in the month of May also he was given an opportunity to come. Last portion now, 37. Last portion.
Kindly see the page 37, the date on which it was signed. 29th November 2023.
Maybe
Notice was signed on 29th November.
Beforehand it was issued.
show causes.
The date is
We cannot.
date of appearance is preceding the
But
date of
yes, I
signature.
cannot.
Notice was issued later.
But this is a mistake.
Then
And summary of so-called notice was also issued on 29th
on the
November.
same day.
And one of the time to file reply was on 26th December. Next page, 39.
26th December, he
No.
prayed for adjournment.
On 22nd, I filed an application for adjournment.
But before the appellate authority also, you have not been able to produce. What to do about
My lord,
that?
that documents, I say, my lord, that upon instruction, my lord, that they have produced all the documents, my lord, which require, because, my lord, under the GST law, my lord, everything is on the portal, my lord. I have to produce the physical evidence that these are the invoices, my lord. There is no dispute that the supplier has not shown the supply to me, my lord. Because of some discrepancy, my lord, the claim of ITC was disallowed or that tax under the RCM was asked for, my lord.
There are two things. When at uploading of documents or producing the same before the appellate authority are two different things. But whether he has produced or not,
My lord, the tribunal is,
You take instructions and
my
come.
lord, tribunal is not functioning, my lord. Otherwise, my lord, I could have produced the, because tribunal is the last fact-finding authority,
Yes.
my lord.
That is
So-
why one thing we can do, I can admit the writ petition, direct exchange of affidavits.
Yes,
we
yes.
can do that.
And
Your Lordship, in this matter, I am appearing for the Union of India, my lord. Respondent number 7, my lord.
Very
because, my lord, the notifications under are also under the challenge.
You've challenged the notification also.
Yes, under section 168.
Where is no prayer is there? I
Yes, there is.
There is a prayer.
Yes, yes. My lord,
Yes.
prayer
D.
D. Yes.
Then I'm admitting the writ petition.
After this appellate order, my lord, they have recovered, my lord, entire amount of the tax, my lord, which is due. My lord, in normal circumstances, the tribunal is functional, my lord, then petitioner was required to pay only 10%.
10%.
My lord, what I am humbly submitting, my lord.
You have any evidence of the recovery?
Yes, my lord, I have annexed, my lord, the electronic credit ledger, my lord, debiting my amount. Page number, my lord, 78. Onward. Taxes under three heads, my lord, IGST, CGST, and the SGST. The first one is, my lord, relates to the IGST head, my lord. Your lordship will find.
Page 78.
Yes, 78 onwards. I have done, my lord, page number 79. The demand was, my lord, 5,43,341.
Yes.
Thereafter, my lord, at the time of filing appeal, I paid 10%. The lordship will find there is a credit. 54,334.
34.
5.
Ah.
Thereafter, my lord, after passing the appellate order, column serial number 5, my lord.
Yes.
The amount, my lord, remaining amount, 4,88,945 was recovered. Now the tax due, my lord, your lordship will find in the last column central tax balance.
0.
0. So the entire amount of tax has been recovered, my lord.
So then in that case, stay should be granted because
no further. Yes, can stay.
My lord, but in other cases, my lord, this honorable court was pleased to, my lord, refund the amount which is in excess of the 10% of the tax in dispute, my lord.
that is that was a different case where
No amount was recovered, my lord.
no,
in excess
but
of
the amount was recovered after filing the appeal before the first appellate authority. I've gone through that judgment. There it has been said that you refunded. It was not a case of second appeal. I mean, before the appellate tribunal.
But my lord, had the tribunal been functioning, my lord, then I was required to pay only 10% of the tax in dispute. So this amount, my
That's
lord,
there, but
tribunal is not functioning, my lord. There is no opportunity to, my lord, file the appeal.
refund is difficult at this stage. Interim stage, directing refund, setting the clock back will not be proper. If you win the case, you will get it in any case.
My lord, in this case, Here also, my lord, what happened? You have filed appeal. The appeal was rejected, my lord. Dichi. Last paragraph, my lord. Paragraph 5.
This is because the appellate order was set aside.
Appeal was rejected, my lord.
This was because the appellate
Appellate
order
order
was
was
set
set
aside and appeal was restored.
Yes.
So in that situation, yes, because the appeal is yet to be disposed of. Here I am not
My lord,
restoring
here I
the
am
appeal.
unable to file the appeal, my lord. Here I am on better footing, my lord.
No, you are unable to file the appeal before the tribunal.
In this case, my lord.
Yes, therefore the order has in one sense attained finality till such time it is
Petitioner
upset.
should not
That
be
is
prejudiced, my lord, because, my lord, kindly
difficult to refund in this situation because the situation is different. I have seen an order passed by the same honorable judge where he has directed the authority, the petitioner concerned, to make a representation for refund.
division-based judgment is there, my lord. I am not finding, my lord. I will, if your lordship.
Bring it then. I am making it not today.
Great, lordship.
Next, kindly fix it on next week.
Next week. Heard learned advocate appearing for the parties, full stop, has prayed for list the writ petition for further consideration on when should I keep? November 20? November 20.
Grateful, lordship.
Give your reference. I have not dismissed it. It will appear as under the heading for dismissal on a particular day.
Your lordship,
24%.
your lordship, your lordship, item number 27, not this, we're praying for not this.
I'll come back and then pray.
Only prayer lordship is the matter.
Extremely grateful, my lord.
or import of the goods for the amount that the GSTR when you know the GSTR is the automotive form, wherein the amount of tax paid by the person who is importing the or the person to whom I am purchasing the input tax reflected in the GSTR. So the authority found that the amount to the extent of 4,92,000 paid by the petitioner was not reflected in the GSTR. So there was a mismatch in my total claim of items made in the return of GSTR and GSTR. We issued a so-called notice. So we produced all the documents before the authority. So after certificate of the past order, against that we filed an application report on the ground that we did we filed an appeal. We produced all the entries on the bank statement and the challenge, evidencing that the entire amount has been paid. So the authority allowed the amount in part to the extent of 29 lakhs. But the finding is by the contrary to there must be finding the update order. Kindly come to page number 110. The relevant order starts from page number 107.
Yes.
Para 6.3. 110.
Yes.
On examination of the documents through I-State portal, it is found that the following bill of entries have not been reflected in the GST portal during the period financial year 2020. So he is saying that these bill of entries were not reflected in the portal out of total 89 lakhs, 84 lakhs. Now he is allowing those bill of entries and disallowing balance. That is the next paragraph after the table. As his claim of input tax rate is allowed to the estate of rupees 20 lakh 71 lakhs.
So therefore he accepts that yes, these bills were not there, but you have already paid duty on that, therefore they are exempted.
My claim is that 54 lakh I have paid. I produce all the documents, it's an evident time. So it is the recording of the update of the time produce the document there. That bill of entry and the payment of the salam, it will be a copy of the bill of entry. He is saying out of 84 lakh, he is finding that 7 bill of entries were not found in the portal. I scale. Therefore, well, this amount has to be disallowed. But he is allowing this amount which has not been found in the portal. The self-contradictory finding.
Yes, Mr. Chakraborty. I thought that since they were not reflected in the portal, but he has produced that, he has found that yes, those have, although they have not been reflected in the portal, but actually, because it happens at times when bills are processed manually, in one of the cases I have heard that, if bills are processed manually, payment is made manually, then there is no reflection in the GST portal, that is disallowed. But if the authority finds that yes, it has actually been paid, it takes that into consideration and says that although it is not reflected in the portal, I am allowing you credit. I thought in that way, but his contention is that these were actually not paid. So these ought not to have been allowed. What has been paid should have been allowed. Instead of allowing what has been paid, they have not done that, and they have allowed what has not been paid, which should have been disallowed. Yes, I have got it.
It is a case where both should have been agreed.
Yes.
But may I come back because this I have to take factual instruction.
No, authority has to allow the bill of entries payment based upon my bill of entries. It's not going to raise any doubt on the veracity of the bill of entries.
No, but these bill of entries have also been paid. In respect of this also customs duty has been paid or not.
Yes, yes.
So why do you say that this should have been disallowed? This also should have been allowed.
He's saying in the veracity that these are the bill of entries which are not out of the agreement.
Yes, but
There are so based
so according to me, the logic is that although they are not found on the GST portal, only that will be allowed. Then this does not make sense. Where do I get that is the finding?
Kindly see, I have produced all the documents that finding are not
No, but Mr. Dugar, these bills of entries which have been shown in serial numbers 1 to 7, were these bills of entries paid or not? These were also paid. You have made claims in respect of this also. So therefore, this logic of his, that although this has not been reflected in the portal, but he is satisfied that this has been paid, therefore he is allowing, that cannot be faulted.
Then, my lord, if this is the logic, then the entire claim has to be allowed.
The other one should have been allowed.
Yes,
That is a different thing, but
then it
this,
is allowed. So,
and what is the reason for not allowing that?
see, no reason has been given because of funds that those were not authorized.
Because he has written that upon examination of the document, it is found that the bill have not been reflected.
Yes.
Hence this claim, so this he has been satisfied that they were there and have been paid. This is my understanding of this.
It's not that we have produced the document, so I am allowed.
No, he said that 6.3 yes. Upon examination of the documents through ICGate portal, it is found that the following bill of entry have not been reflected.
So these bill of entries have not been reflected. So it has to be disallowed if that finding is considered as correct.
No, previous finding.
Previous finding you are not
Yes,
finding
at the
for-
outset, learned authorized representative on behalf of the appellant argued vehemently that impugned adjudication order is such and such, come to the line beginning but again some bills of entry. The customs had not uploaded the IGST amount on the GST portal. As a result, yes, so in apropos this conclusion is drawn that although these were not there, but payment has been made, and although he has not recorded it in so many words, but it means that he is satisfied as regards the payment of this. But yes, so far as the dissatisfaction as regard the payment of the other portion, there is no finding on that. Yes, Mr. Chakraborty, take instruction on this,
Yes, ma'am.
so that if he is satisfied with regard
It
to
has
this,
to be, the same standard has to be applied to
yes, or if he has not applied the same standard, or if he finds that the same standard cannot be applied, then in that case he should spell out why he is not agreeing,
there has to be a reason.
allowing that. Very well. Because I find sense in what he has written upon reading the earlier paragraph. It shows that only, that he has, it's actually lack of sense of explanation language. That is the problem. Otherwise, he has wanted to say that only.
Para 6.2, last three lines below. In course of hearing, he furnished invoices in both bill of entry issued by customs and bank statement. My claim was that the entire amount has been paid by you. Therefore, you have to allow the entire thing. Now, my lord is saying that I did not find just note from that portal, and I will
Come back so that I can decide this.
Yes,
This can be sent back if
Yes, ma'am. Yes.
I'm keeping it this week only then, because it's a small issue in any case. The writ petitioner assails an adjudication তাহলে 20th এটাও সেম দিন রেখে দেব 20th not this week. An adjournment is prayed for on behalf of the petitioner. A week's adjournment is prayed for.
I'm for the respondent number 5, Major.
Not today. এক লিখে রাখবেন সবকটা যেগুলো সবকটা আজকে অ্যাডজর্নমেন্ট হয়েছে সবাইতে এক এক লিখে রাখবেন
নাম হবে কবে থাকবে
not today means tomorrow again it will be taken up. Yes.
For the respondent.
Tomorrow. Ma'am, please take the mic.
My lord, I am aggrieved with the order of the adjudicating authority as well as the appellate authority on the ground of law, my lord, only on legal principles. And I feel, my lord, it would be my endeavor to convince your lordship that it is a case fit for entertainment by the writ court under Article 226 of the Constitution. Now, my lord, the fact of the case is, my lord, that the petitioner is the owner of a petrol pump. And the petrol is supplied by Bharat Petroleum Corporation Limited, which is the pro forma respondent number 5. And my lord, it is a government of India undertaking with the government having 52% of the shareholdings, which has been stated, my lord, in my petition. And therefore, it is a state within the meaning of Article 12 of the Constitution of India. Now, my lord, the BPCL provides me with all the petroleum products, my lord, which is not on which GST is not leviable. But my lord, the petitioner also owns tanks. He's a tank owner, for which he carries the petrol from BPCL's depot to his own petrol pump. And my lord, that is called Goods Transport Agency Service. They're carriers, and under the law, my lord, the recipient of the service can pay it on reverse charge mechanism, the tax he's done. Now, what he has done, my lord, so all there was that Bharat Petroleum Corporation, my lord, pays the tax on reverse charge mechanism, and the petitioner does not have to pay GST on this. But what happened, my lord, by mistake, in the profit and loss account of 18 and 19, my lord, it is written a certain amount receipts from income from tanker rent. So when the authorities, they scrutinized my returns, and also not in my returns, but in my profit and loss account. When they called for the profit and loss account, it was shown, my lord, that these were the receipts. Then, my lord, what they did, the respondent number 1, the adjudicating authority, issued a pre-show cause notice in DRC 01A. In the 01A, it was stated that you have shown receipts from rent of tank, but you have not paid the tax. And, my lord, it stated that it is in the 018, it is stated that section 74 is invoked. My lord, no allegation of fraud, willful misstatement, or suppression of facts. The only ground is that state revenue needs to be protected. Now, my lord, your lordship is aware, 73 also says that if tax is not paid, short paid, or income ITC is wrongly, input tax credit has been wrongly availed, then they can proceed against me. But it is without fraud. And 74 says, because the penalty is higher. And my lord, assuming for the sake of argument here, though not admitting, if every short payment of tax does not amount to, my lord, the section 74, for them to invoke the extended period of limitation. Now, my lord, to that DRC 01A, he filed a reply. He stated in that reply that, find out the page, he stated in that reply that it was a mistake in the profit and loss account. I am providing carrier service, transport service to BPCL. BPCL pays the GSTR. And my lord, 3 documents at that stage, which has been admitted by the authorities, he produced. One was, my lord, that is my lord, tax invoice showing providing GTA services. I'll show the pages, my lord. Then chartered accountant certificate that the receipts were from service rendered as GTA. And, my lord, a statement of consignment note issued by BPCL. These are the documents. My lord, your lordships may kindly come to page 59. My lord, at page 58, my lord, in the last paragraph, kindly see, my lord.
Yes.
He asserts there is no requirement for paid on income from tanker rent in this scenario. In support of his claim, he has submitted invoices of supply for GTA services generated by the RTP and charged tax at 2.5% each, CGST and SGST respectively, to the respective OMC, that is oil manufacturing company, for transportation of goods by road. So, my lord, his invoice had that he was rendering GTA services. Now, my lord, kindly come to page 59B. A certificate from the chartered accountant who audited the books of accounts confirming the account figures of income from tank rent supply for GTA services. The certificate was furnished, but the same chartered accountant confirming the accurate figure of income from tanker rent as well as supply for GTA services, which showed an ambiguity. My lord, there is no ambiguity. I'll produce. The certificate is annexed. If your lordship sees, my lord, I'm producing certificate, page 63. My lord, no, not 64. My lord, kindly come to page 64. This is the certificate of the chartered accountant. To whom it may concern, we do hereby certify that in the profit and loss account for the financial year 2018-19 and 19-20 of Haradhan Chatterjee carrying on business under the trade name of Ma Auto Center and holding GSTN number such and such, the income from tanker rent as appearing in the final account were actually the amount earned on account of providing goods transport agency GTA service to Messrs. Bharat Petroleum Corporation during the said financial as follows. My lord, he has given the year and the amount that was received. So, my lord, I do not find any ambiguity that what was shown as tank service on income from tank service was actually amount earned on account of providing goods transport service. My lord, he has given this certificate. My lord, also, my lord, at in page 59C, my lord, kindly see a statement of BPCL has been given, my lord. That is the page 15. My lord, see, consignment B, no? B, it is B. Sorry, my lord, it is B. It is said, my lord, that all consignment notes corresponding with invoices of supply for GTA services generated by the RTP, but consignment notes were not furnished. A statement of consignments produced which generated by the consignor BPCL and mentioned consignee Messrs. Ma Auto Carriers as stated by the AR of Ma Auto Center. My lord, this document was also produced. So the BPCL, my lord, which is a government of India undertaking, is admitting that it is the petitioner has been only providing services as a carrier and they have not let out the tanks to them. Now, my lord, this was, but then my lord, may kindly come to page 60. No, my lord, kindly page 61. My lord, to safeguard the state revenue, no other, my lord, allegations. Proper officer of the case proceeds to issue show cause.
Page, madam.
Page 61.
Page 61.
61. He considers this, but he still is not convinced that the petitioner is providing service as a carrier, as a GTA. So he says, to safeguard the state revenue, the undersigned proper officer of the case proceeds to issue show cause notice under Section 74 of the GST Act and Rules 2017 in the portal after uploading an order of attachment.
Yes,
so, my lord, there is
issued.
show cause.
How do you reply to this?
Yes, my lord. My lord, kindly come to page 62. My lord. As per your information and notice under Section 74, owns a pump vendor, code number such and such, for supplying diesels. The RTP owns an oil tanker and transport petrol and diesel in its capacity as a goods transport agency, submitted consignment notes and also auditor's certificate for clerical mistake in PL accounts. OMC pays, that is, my lord, the BPCL, the GST through reverse charge mechanism.
What is the full form of OMC?
Oil manufacturing company, my lord. Oil marketing company. Pays the GST through reverse charge mechanism, RCM, enclosed herein. Certificate produced by Messrs. Bharat Petroleum Corporation Limited. So Bharat Petroleum Corporation Limited has also, my lord, issued a certificate. Regarding inward supply of transport goods, already submitted necessary documents before you. You also admitted it accordingly. Besides this, any detailed clarification required from your end, you may proceed accordingly. Documents uploaded. My lord, kindly see the documents. My lord, page 63. My lord,
Given that they have received transportation service from you.
Yes, my lord. And my lord, they have said they have paid on RCM basis the tax on that amount, my lord. They have paid. My lord, they did not consider this. And again, my lord, they have passed the order holding it, my lord, that he's renting out tankers and he is not a carrier, a GTA service provider. And my lord, this is and again, my lord, it is said in the final order, whatever was in the show cause notice, they confirmed, and in the final order at page 71, my lord, it is written, no allegations that I have committed fraud, willful misstatement, or suppression of facts. My lord, to safeguard the state revenue, the undersigned proper officer of the case proceeds to issue demand notice in Section 74(9). Now, my lord, so far as the adjudication proceedings is concerned, my lord, my grievances are that I had produced. My lord, may I submit? He did not consider all these documents.
How is the appellate authority dealt with this?
My lord?
How has the appellate
Yes, my lord. Before, my appellate authority went to a totally different ground. But before that, my lord, may I submit, my lord, that the appellate authority did not consider why my documents were not accepted. One is, my lord, the adjudicating authority said that a goods transport agency must issue consignment notes. My lord, I have issued consignment notes, but because I've already stated earlier, my lord, the whole thing happened in 1819, and all documents are lying with the Bharat Petroleum Corporation, and in such a short time, it is not possible for me to retrieve all the consignment notes. My lord, 365 days, and maybe not one trip, maybe doing multiple trips. So, my lord, how many consignment notes? It couldn't, but I have showed other evidence. No, my lord, why my evidence could not be, my lord, appreciated, and it ought to have been appreciated, my lord. On this, my lord, I am Section 30. My lord, yes.
Section
58, I'm preaching the book to you of my lord Bharatiya Shakshya Abhinaya. Section 58. My lord, may have my book. I will see from this book. My lord, only thing I have highlighted. My lord, I've given to my lord my book. My lord, it says what will be a secondary evidence? 58. 58. Secondary evidence. Yeah, Shaksha Abhinaya, yes. 68. Primary evidence is there, and there is, my lord. Oh, sorry. My lord. 68, my lord. It says kindly come to 58, my lord. 7. It says secondary evidence. My lord, let us assume I could not produce my original consignment notes, but I have produced secondary evidence. Secondary evidence is written admissions. My lord, BPCL has given a statement of the consignment notes and also stated that he have paid the tax consignment. And now, my lord, kindly come to page, section 60, no, wait, just a second. Cases, my lord, 60. Cases in which secondary evidence relating to documents may be given. When can I give secondary evidence? Now, my lord, come. My lord, C, my lord, 60th C. When the original has been destroyed or lost, or when the party offering evidence of its contents cannot for any other reason not arising from his own default or neglect produce it in reasonable time. I have produced that. So, my lord, this secondary evidence ought to have been considered. Now, my lord, what are they relying on? Their only ground that this is not GTA service is what has been written in my profit and loss account. In that respect, my lord, I'm also, my lord, kindly come to section 34, I think, section, my lord, no. Section 28. My lord, section 28 of this act.
Saksha Diniyam?
Yes, ma'am. Saksha.
Oh, we boita din.
Section 28. It's very, very expensive.
Section 24.
28, ma'am. 28. Entries in books of accounts. My lord, how they are to be treated. Now, he has found it from my profit and loss account that it is written as receipts on account of tanker rent. Now, my lord, section 28 says, entries in the books of accounts, including those maintained in an electronic form, regularly kept in the course of business, are relevant whenever it refers to a matter into which the court has to inquire. But such statement shall not alone be sufficient evidence to charge any person with liability. My lord, I have other corroborating evidences to show that it was a mistake. Chartered accountant has said it is a mistake. The consigner, BPCL, has also stated, it has given the list of the consignment notes and it has stated it has paid the tax. Now, my lord. And my lord, so far as section 74, no reasons has been given there was fraud, willful misstatement, or suppression of facts, simply to protect the revenue. Now, my lord, against appeal. Yes, my lord. Yes. Now, my lord, in my appeal, I took all these grounds. I said that from page 90, no, my appellate. Fine. I'm showing where have my appeal has been. My lord, I have stated that wrongly invoked section 74 and everything I've stated, I have also page 73. My lord, from page 73, my grounds of appeal. No, my lord. I have taken all these points, my lord. My lord. My lord, page 79 are my grounds of appeal. My lord, I've written, my lord, that, my lord, has it met at my submissions? My lord, that the appellant submits that since a long period of more than 3 years had elapsed since the annual returns of GSTR 9 and reconciliation thereof has been filed, and also since the appellant only dealt in non-GST goods, the relevant records for transportation of goods could not be retrieved within such short period of time as has been allowed in the instant case. The appellant submits that a narration against any entry in the profit and loss account cannot be conclusive proof to judge the nature of a transaction unless the actual nature of the relevant transaction is considered, particularly where the auditor has clarified the exact nature of the relevant transaction in a subsequent rejoinder. Then, madam, it is further submitted that if the certificate dated such and such issued by the auditor to the effect that the relevant receipts reflected in the income from tanker rent in the profit and loss account were actually on account of provision of GDA services appeared to be ambiguous to the learned adjudicating authority, an opportunity for further clarification ought to have been allowed to the appellant to clear the doubts in that regard. And in not doing so, the principles of natural justice were violated. But my lord, your lordship has seen the certificate, my lord. According to my humble submission, there is no ambiguity. Then, my lord, it was also taken that why it is not a tanker rent, my lord. It is said, my lord, page 81. He says, my lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. If the goods vehicle remains in the exclusive control of the consignor and the risks of safe custody of the goods lie with him, there is a case of renting a goods vehicle. However, if the control of the goods vehicle remains with the transporter and the risks of safe custody of the goods transported lie within him, then it is a case of goods transportation services rendered by the transporter. Then, my lord, he also, in paragraph 19, entries in books of accounts when relevant. That also he quoted, my lord. He quoted from the Indian Evidence Act. I quoted from, my lord, BSA. Now, my lord, all these points were taken and also relied on a judgment of the Apex Court, my lord, page 88. That is they relied on Honorable Apex Court in Commissioner of Central Excise Chennai versus Chennai Petroleum Corporation, which I will produce before your lordship. Now, my lord, what did the appellate authority say? My lord, he also stated section 74 should not be invoked. Now, my lord, his order starts from 91. First, he says personal hearing, submission of the respondents, grounds of appeal, submissions of physical hearing, everything he records. Then he comes to he admits, my lord, page 93, observation of finding. Now, he says, my lord, a detailed study of the order as to operator of petrol shows that the appellant has been engaged in retail business as an operator of a petrol pump and dealing various goods falling under HSL code. My lord, this is not relevant.
Where is the observation part?
Oh, yes, my lord. Yes, yes. Para 8. Para 8. He says, now, yes. No, my lord, kindly come here.
Yes, page 93.
Yes, my lord, 93. My lord, from 7 I'm reading, para 7. At the adjudication proceedings under section 74, the appellate had contended that income from tanker rent had been wrongly entered into the profit and loss account for the year such and such by the auditor, and the appellant transports petroleum oils from the oil manufacturing company, that is, in this case, Bharat Petroleum Corporation Limited such and such, in his own petrol pump through his own tanker of GTA services. And the ONC pays tax through RCM on those supplies at 2.5% under each of CGST and WHS. Curiously enough, my lord, yes, this is the agreement between the aforesaid OMC and the appellant, valid for the financial year 2018-19, as per letter dated 22/1/25 by the OMC, that is BPCL, bearing agreement number such and such for the period from 2017 to June 2023, has been not traceable. And instead, the OMC had provided to the appellant the agreement number 6813, such and such, with effective from 1/7/2017 to 31/2/12/18, claiming that content and terms and conditions for transport agreement have been same for both the agreements.
He says that your original agreement was not there with you.
Yes, but they have produced an agreement saying that the terms and conditions of the original agreement were the same as this agreement. Now, my lord, I have attached the agreement on which the appellate authority is relying. First, he says that this cannot be relied upon. Now, in this regard, we can visit the provisions of section 58 of the Bharatiya Shakshya Adhiniyam. And then, my lord, he says what is secondary evidence. He gives, my lord, whatever your lordship has seen in the book is there. Now, essentially, now I'm coming to the bottom part. Essentially, section 58 broadens the scope of what can be presented as evidence when the original document is unavailable or impractical to produce in court. However, nowhere it allows the agreement for subsequent period to substitute the missing agreement, that is the primary agreement. Then he comes. Even if we go through the present agreement, now, my lord, he is abandoning that fact that the original agreement was not produced. But if we go through the present agreement, what do we see? We find that the heading has been agreement for hiring of tank lorries for movement of petroleum products, wherein Messrs. Bharat Petroleum Corporation has been called the company and the appellant. Mao Auto Center has been called the carrier and includes the following clauses. Clause 1, the carrier will provide the company with number of tank lorries for transporting petrol. Each of the tank lorry would be attached to a particular loading location storage point of the company as.
But here, madam, he has a point.
My lord?
The appellate authority has a point. If it is only service,
yes,
then the control of the truck will be with you.
It is with me. It is also in this. I'm showing the agreement on which
doesn't say so.
My lord?
Agreement says otherwise.
No, my lord, but I'll show the relevant provisions of the agreement, my lord.
Page 6,
No,
paragraph 10.
Page 6, paragraph 10, my lord.
Page 6 of the internal page 6 of the order, that is page
Yes.
95 of the writ petition.
Yes, my lord, my lord. I'm producing for page 90. 90, yes, my lord.
Paragraph 10, about 5 lines from the bottom of the paragraph,
Yes.
there is a sentence beginning further these.
Yes.
Further, these tank lorries shall remain under exclusive use with the company throughout the contract period.
Yes, my lord.
This shows a sense of rent.
My lord, no, my lord. Now I'm reading out from that. Agreement.
Prima facie, it doesn't appear that,
my lord, first I'll
it was services.
My lord, first I'll let you know. I'm coming to page 30, page 39. No, 40. My lord, 40 is, my lord, although it is written agreement for hiring of tank lorries for movement of petroleum products, it says agreement between BPCL and, my lord, Ma Auto Traders as carriers, not, my lord, as rentals.
Not required. As carriers, yes, okay. But
yes, now, my lord, I'll show you the clauses, my lord, which shows the whose control it will be. No, page 43 is also there. My lord, everything has to be done. My lord, while, my lord, kindly come to 3. Uniform specification. I am engaging the people. And
how is services defined under the Act?
I'm coming. My lord, page 44. 44. No, my lord, I'm coming to, my lord, kindly come to page 44, 44, my lord, under 6.3. 6 subclause 3, my lord. My lord, BPCL will, my lord, has it, my lord, page 44? 3. 6B3, my lord, 6B3. BPCL will be paying GST to the government on the basis of reverse charge mechanism, which is currently 5% of the transport rate. Page, my lord, 44. My lord, kindly, my lord, 6, paragraph 6 and subclause B3.
BPCL will be paying GST to the government on the basis of reverse charge mechanism, which is currently 5% of the transport rate. And if any bidder opts for GST payment on the basis of forward charges mechanism, which is currently 12%, then the bidder will have to reduce the transport rate to match with the rates with L1 rates with 5%. So my lord, here he's saying that he is paying on reverse charge mechanism. My lord, no, my lord, it is also kindly see page 44C, top. My lord, page 44C, another clause. It is agreed that tank lorries covered by this agreement shall operate at the sole risk of the carrier. So, my lord, it is my risk. It is not, I have not lent it out to him, rented out to him. So, if anything happens to him, he will be responsible. It is completely under my control. And in no case, company would be held responsible for any loss or damage done by the tank lorry while on the company's work or parked in their premises or anywhere else. So it is totally my control. Then next, my lord, kindly come to page 45. What I have to do. They were talking of consignment notes, my lord. My lord, kindly come to G. The carrier would provide consignment notes for each consignment loaded on a daily basis to the loading location. So it is mandatory on me, my lord, to produce consignment notes. The carrier would provide transportation bill along with the consignment notes for each consignment.
Yes, Mr. Chakravarti.
Yes.
I'd like to find that. They will be a coming after the appeals. There is a factual, some factual disputes are there, but subject to correct, because the interpretation of the agreement, because agreement also contemplates it can be a forward mechanism if the rates goes down, which my learned friend has just read out.
Yes.
So this has to be considered in the light of what is there. Does not show to be an arbitrary order. There's some logic to it. What I find subject to correction.
Let him file his affidavit.
My only thing, my lord, and since BPCL has stated, my lord, that it is a government of India enterprise, it has paid the tax. Kindly give me protection, my lord, till such
Then
time.
you'll have to deposit something.
My lord, already tax has been paid, my lord.
That is.
My lord, they have paid the tax, and my lord, there has
See,
been, they have not.
If the tribunal had been there, you would have had to deposit 10%. Deposit that, take stay.
My lord,
I have been passing that order.
my lord, something less, my lord. It's a poor, he's a small amount, whatever. I don't want to say, but my lord, kindly.
This writ petition assails an order dated July 29, 2025, passed by the Appellate Authority under Section 107 of the WBGST Act, 2017, whereby the petitioner's appeal against an order dated December 12, 2024, passed under Section 74 of the said Act of 2017, was dismissed. Full stop. Paragraph. Ms. Mukherjee, learned advocate appearing for the petitioner, submits that both the adjudicating authority as well as the appellate authority have failed to appreciate that in the facts of the present case, provisions of Section 74 of the said Act of 2017 could not have been applied at all. Full stop. It is submitted that the GST authorities have wrongly interpreted the expression tanker rent to be rent only, despite clarification being given by the petitioner through the petitioner's not only through the petitioner's chartered accountant, but also through the company to whom the petitioner had been rendering services, that the petitioner was actually a goods transporting agency, i.e., an entity offering carrier services full stop, paragraph. It is submitted by Ms. Mukherjee that although the order impugned is appealable under section 112 of the said Act of 2017, yet since the tribunal has not yet become functional, the petitioner has no avenue to assail the order impugned. Full stop. In view of the aforesaid facts, the writ petition is admitted. Full stop. As prayed for by Mr. Chakraborty, learned advocate appearing for the state respondents. The respondents shall be at liberty to file affidavit in opposition to the writ petition within 4 weeks from date. Reply, if any, may be filed by the petitioner within 2 weeks thereafter. The matter shall be listed for hearing immediately after expiry of the time fixed for exchange of affidavits. Full stop. If the petitioner deposits a sum equal to 10% of
The balance amount, my lord, of the balance disputed amount.
Yes, I'll use the statutory language. 10% of the remaining amount of tax in dispute in terms of section 112 within bracket 8 of the GST Act of said Act of 2017, to the GST authorities and furnishes proof thereof to the said authorities within 2 weeks from date, the respondent GST authorities shall not proceed to recover any sum on the strength of the order dated
25.
December 12, 2024, passed under section 74 within bracket 9 of the said Act of 2017, which was affirmed by the order impugned herein. Full stop. Until further orders. Full stop. That's it.
I'm grateful.
May it please your lordship. Time for the petitioner. My lord, this is one of those matters challenging notifications enlarging time under 168A of the GST Act. My lord, the appellate order which upholds the order in original and relies on the notification, my lord, is also under challenge. But my lord has an occasion to consider this. I was assisting my learned senior is one of those matters.
Yes, yes.
One of the only trouble that I'll have to trouble my lord with is one aspect is that my client is humbly praying for stay. But in this matter, my only endeavor is, my lord, today can it? I bow down before my lord. Can it kindly be 5% instead of 10%, my lord? Only to that I have.
Since it's appellate order.
Yes, my lord. I fully realize, my lord. It's a small concern, my lord. We are having cash crunch, my lord. I make a clean breast of the facts, my lord. The matter is actively under consideration by the other honorable high courts, my lord, where stay unconditionally has been granted. I do not oppose deposit, my lord. Kindly consider this. Kindly make it 5% instead of 10%, my lord.
If you would have come against the show cause notice, then yes, I would have considered. 2 stages crossed. Before the appellate authority, if you would have approached the tribunal, then in that case 10% would have been the. Or you take that order that you will file an interim application whenever occasion so arises, then we'll consider.
The client humbly requests for stay, my lord.
Pay 10% and get it. Because let us be uniform in the practice that
in a matter where validity of notifications, my lord, is under challenge. Slightly.
My lord had passed 5%.
Yes, my lord. Only this.
That was adjudication order.
That is
well, there are, if I understand correctly, my lord, there are orders where
and
the
I
honorable justice
to state, but I granted. I entertained the writ petition with 5% because delay was not satisfactorily explained.
Yes, delay.
In the year 2024, my lord, the very first leg of litigation, the Honorable Justice Nizamuddin, as his lordship then was, had been pleased to grant unconditional stay. The Honorable Justice Raja Basu Chaudhary, in the first stages of this year, my lord, had been pleased to grant
Yes, but
unconditional.
lastly,
Yes, my lord,
it was
there are some orders. I
Convince the court because ultimately this companies or whatever this goes for liquidation, my lord, normally no one tax doesn't been lodged.
I do
have
not stand in the way, my lord. Kindly make it 5% in this matter, my lord.
because see 5%, 10%, it becomes very arbitrary. Where 5, where 10. Let it be unique 10% because this is in tandem with the statute also. Statute says 10%, deposit 10%, take stake.
As my lord pleases.
32 থেকে
32 to
37
38.
38.
না তো স্টেটের মামলা আছে
32 to 38 or
Yes.
32 and 38? Which one? এটা দেখুন কার
Well,
হয়ে গেছে।
32 মানে all century products matter.
Huh?
32, 33, 34. 35, well, all century, same matter.
32 to 35.
5, thereafter, well, 37, 38.
Very well. Now original site will be called. So in any case, it is not today.
Grateful man.
So original site. Yes.
Have some difficulty. My for that I'm praying for not today.
Not today.
Only not today. Maybe kept on Thursday. Not actually. What happened?
Thursday,
Or any day.
tomorrow?
Not to tomorrow. Second half. Okay. Dip.
3 p.m. Same time. Difficulty tomorrow.
No. Actually, what happened was soft copy is not opening up. By mail it came. Now 2 parts are not opening up. Otherwise, I have it here.
So you want it Thursday?
Thursday or just tomorrow, so that they can send the hard copy.
এটা Thursday করে দিন। কোনো অর্ডার করছে না? এই 1 and 2.
Deeply obliged.
Thursday. You please bring the appellate order also. You said that there is an appellate order by which.
Millards. I have annexed the sestats order in the company's case in the brief only, Millards, which set aside the order in original.
But no appeal has been preferred against that sestat.
Yes, there has been, Millards, to the Supreme Court. There is a
That should be allowed then.
Millards, that
The
is
order on the ground on which the order was set aside is no longer.
no longer good law. But Millards, there is a small hiccup over there, Millards. It is below the monetary limit, Millards, for appeal. So
But that makes your case worse on that ground.
Yes, I understand, Millards.
Jurisdictional ground, it was on the ground on which it was set aside.
Yes, Millards. Yes, Millards. I understand.
Very well.
Bye.
Number 3. Yes, Mr. Bhattacharya.
My lord, I am referred my reply, affidavit in opposition and reply.
Yes.
In page 2 of my reply.
Page 2 of your reply.
In opposition, respondent authority, revenue respondent authority, admitting the patent illegality in passing the assessment order against Kripa Shankar Mahawar on the basis of the PAN, no deceased PAN number of the deceased father, Lokshikanta Mahawar. Kindly look into the page 2,
You are
paragraph 3.
Para 3, admitting the patent illegality.
They admitted the fact. In their paragraph 25, and
Yes.
Kindly look into the page 6A, paragraph 16 of my reply in page 6. Paragraph 16. In the case of, in view of the above, I state that the statement in the affidavit in opposition are false and hid by the constitutional bench decision, and further explanation of affidavit is not permissible in this stage. In law is laid down by Mohinder Singh Gill and another versus Chief Election Commissioner. Thereafter, my lord, a same matter referred by the Gujarat Division Bench, and that order also 2021 affirmed by the Supreme Court. This division bench judgment is affirmed by the Honorable Supreme Court. Gujarat High Court Division Bench. Two 2021. Page 2, paragraph 6, my lord. Yes. A notice under section 153C of the Act 1961 dated March 29, 2019 came to be issued in the name of the Bhupender Bhai Bhikalal Desai after a period of 7 months from the date of the notice under section 153C of the Act 1961. The son of the deceased, namely Raju Bhai Bhupendra Bhai Desai, gave a reply dated October 9, 2019, informing the department for the first time that his father passed away was back on April 23, 2017, and that the notice was issued to a dead person and therefore the proceeding be dropped. Yes. This principle is upheld by the Supreme Court. In page 8, page 8, second paragraph, my lord. Second paragraph, middle of the portion. Reliance was placed upon the decision of the court is Rashid Lala versus ITO 2018 11 ITROL 212 Gujarat and 2017-77 taxman.com 39 Gujarat, wherein the notice under section 148 of the Act was issued to the assessee long after he had passed away. The heir of the deceased informed the assessing officer that the assessee has passed away and therefore the notice under section 148 of the Act is invalid, despite which the heir was told to file the return of income in compliance with the said notice. The court held that the notice issued in the name of the dead person was not valid and that despite being informed about the death of original assessee, the assessee, instead of taking corrective measures as provided under section 292B of the Act and issuing fresh notice to the heirs of the deceased, continued with the reassessment proceedings against the dead person. The court further held that the section 159 of the Act would not be applicable to the facts of that case, and that even if section 159 is attracted, the notice was required to be issued in the name of the heirs of the deceased assessee. Kindly look into the next page, page 9. Second para. This court supports such conclusion. Then I read the relevant portion in third paragraph. In such circumstances, the question would be as the whether section 159 of the Act would get attracted. The answer to this question would be in the negative, as the proceedings under section 159 of the Act can be invoked only if the proceedings have already been initiated when the assessee was alive and was permitted for the proceedings to be continued as against the legal heirs. The factual position in this instant case being otherwise, the provisions of the section 159 of the Act have no application. My lord, kindly look into the page 25 of the Honorable Supreme Judgment. Page 25, para 29. Ultimately, in view of the aforesaid, the only proposition of law that is applicable in the present litigation is that a notice, be it under section 148 of the Act or section 153C of the Act, issued to dead person, if unenforceable in law, if such is the legal position, the Revenue Court contended that as they had no knowledge about the death of the assessee, they are entitled to plead that the notice is not defective. So, my lord, in the writ petition, page 70, the assessing officer passed a impugned assessment order in the name of Lokhi Kanto Mawar, again, page 70 of the writ petition.
Yes.
Page 70. Page 70. They use the PAN number of deceased person. That is not permissible.
Page 17.
First, my lord, page 22. They issued in the name of the deceased assessee notice.
Yes.
And finally, they passed the assessment order in the name of the deceased assessee and use the PAN of the deceased assessee. They never use the PAN of the deceased assessee. That is the Constitution bench upheld the order of the Honorable Gujarat High Court. কি করে দেখাবো এটা? It is 6. Paragraph 6, my lord, page 2. Oh. Actually, my lord, I don't have the subscription, so I conclusion part.
Yes.
Kindly pardon me.
No, not a problem.
Only SLP was dismissed.
Main ordering part, my lord.
Notice was not issued.
Contention is the same, section is separate. Already notice issued in the deceased person, name of the. Yes, madam.
Yes. Yes. In this petition, subject to lordship correction, there is a twofold of facts. But one fact is that SSC says that for the assessment year 2021, he has submitted the ITR, the deposited tax, and in the form also, it indicates that in the represented category, the return has been filed in page 20. Now, it is disturbing because it has been filed on 7 January 2021. Now, in my little knowledge, what I have learned in my 5 and 6 years, the Honorable Chief Justice, then Chief Justice, Honorable Justice Sigangon says, if the department want to book properly. Here, department did not book properly assets because what happened in this case? Now, if I say, I cannot ignore the return filed on 7/1/2021. What I understand, when the assessing officer open the portal, it is his knowledge because he, the son of the assessee in the representative category, filed the ITR. It is only possible when department allow the son of the assessee to file the ITR in the representative category and no other. He has submitted. That's why I have also taken some instruction on that. But if that is so, but it is the knowledge of the assessing officer that assessee died, and in that case, initially when 148 inquiry stage, when 148 AB issued, now the initial notice 148 AB issued in the name of deceased assessee. Thereafter, the assessee filed reply, and assessee, when if I say in that way, assessee very cleverly says the father died, he is no more, but it is the duty of the assessee. If he say the only son, that is Lakshmikant Marwar, he has been booked, the assessment order has been passed against him. It is the duty of the assessee to inform the assessing officer who are the legal heir. Because if today the assessing officer have not been informed who are the legal heir of the deceased assessee, and the Kripashankar Mahawar, he only represents and says that the assessee died before initiation of proceedings. He never says these are the legal heirs. Now, may I, subject to lordship correction, may I place section 159? He says subsection 2. May I read out for your lordship? For the purpose of making an assessment, including an assessment, reassessment, or recomputation under section 147 of the income of the deceased, and for the purpose of levying any sum in the hands of the legal representative in accordance with the provision of subsection 1,
any proceedings taken against the assessee before his death shall be deemed to have been taken against the legal representative and may be continued against the legal representative from the stage at is stood on the death of the deceased. Now, my lord, my respectful submission is that, my lord, here the my lord, stage of my lord, reopening, when the my lord, reopening notice was issued 29th March 2023, assessee died. Now, my lord, we cannot deny that, my lord, when the page number 20, when the return has been filed in representative by Kripa Shankar Mahawar, this is the knowledge of the assessee that assessee died, and because I also take instruction, my lord, without, my lord, the copy of death certificate, the representative category return cannot be filed. Now, we cannot deny that. Now, my lord, section 2 subsection A, it says before the date of the assessee, if the proceeding has started, it will be followed to the. Now, my lord,
Legal representative.
now, my lord, my respectful submission, my lord, we are coming in B. Any proceeding which could be taken against the deceased if he had survived may be taken against the legal representative. Now, let here the assessee, what assessee had done. But he has objected. Initial stage, but he has objected, but in the 148A C stage, he said assessee died, but he never said these are the legal representative of the assessee.
No, but the question is if the first notice is illegal.
Yes, my lord,
then
if
that
the
is-
first.
Can it be cured?
No, my lord, I'm submitting before the lordship. Now, my lord, here the escapement in my lord, more than 1,97 lakhs and something, my lord. What I respectfully submit before your lordship, that there is a judgment, my lord, passed by the Honorable Rajasthan High Court and relying the judgment of Honorable Supreme Court. My lord, it says that the order cannot be said nullity, but it also says the notice should be given to the legal representative. My first submission before your lordship was, but if we want to book someone, because we do not want, but for the reason of not giving notice to the legal representative, all the legal representative, if the assessment order goes, then everything will be go, department cannot book anybody. Now, subject to lawsuit correction, may I realize this judgment? Facts is page paragraph number 3. Here in the 2 stages, the AO is directed to serve notice upon the legal heir of the assessees. 2 stages, A did not serve. Thereafter, third stage, the matter went up to tribunal. What is paragraph number 8 and 9? I'm going to paragraph number 13, it is very relevant. But I think, my respectful, this judgment, in paragraph number 10.
Yes, I have read.
This is the Supreme Court judgment.
Difficult to sustain.
But yes, difficult to sustain, and what we are praying before Lordship. Let it go back to the assessing officer. But in a time-bound manner, let the petitioner provide the detail of the legal errors to the assessing officer.
You have copies of these documents?
No, I have not.
My lord, actually, assessing officer never inquired about the legal errors.
But it is
Send the
the
notice to
duty-
only
it is
one
the
legal error.
duty of the
And if for the sake of the justice, I think if any irregularity happened, the Supreme Court categorically mentioned 292 BB, the defective notice cannot be cured by patent irregularities in the initial notice. That is sub lato fundamento cadit opus. If you remove the foundation, superstructure must fall into the ground. Initial cause of action void. Entire
Tax
consequential
liability,
proceeding is void.
tax liability should be paid. Now here is the case that liability has been given upon one of the legal representative. It is his case. Now it is evolved to the estate of the assessee, and now what his contention is the assessee died, tax cannot be recovered because the petitioner never submitted before the assessing officer. These are the legal.
What is the limitation?
It is the 1920, 10 years is there. There is no difficulties.
Very well. I'll apply with my this.
My respectful submission before your lordship, my lord, let the assessee in a time-bound manner within 15 days, provide the details of the legal error. Let thereafter fresh notice to be issued to the all the legal representative, and let a de novo proceeding should be started. And if the assessee within 15 days did not supply the details of the legal all the years, then the order will be given. That is my submission.
My lord, notice limitation period is 21 months. In the
Very well. That can always
I
be
place the order of Supreme Court, paragraph 24. That 21 months is already expired.
I don't know why.
But
My lord, in this matter
my lord,
also Mr. Uday Shankar Bhattacharya is appearing, but he is in the.
covered by various judgment.
Just,
Short point is involved.
My lord, kindly make it.
What is the point, Mr. Mullah?
My lord, the provision is that within a span of 6 months, if the show cause notice is not given, the goods should be released. Various judgments. Various judgments.
My lord, in that last occasion, the Honorable Justice Rajabasu Chaudhary has directed us to submit the document where.
Well, let the hearing be made fast, my lord. But kindly allow me to place the judgments and the facts.
All right, time is short for because it will not be concluded.
Tomorrow.
That is not today.
Not today. My lord, you are going through the records, my lord. I submit that, kindly hear me, and I will show the I will do, place the judgment, my lord, first. Then the records.
My lord, in item number 6, my lord, I appear on behalf of the petitioner, my lord. On earlier occasion, your lord, my lord Justice Raja Basu Chaudhary, my lord, passed an order giving us an liberty to file a supplementary affidavit. May I hand it over? Well, we have already served upon a copy of the supplementary affidavit upon the other side, my lord.
Lordship, I am for state respondent led by Mr. Owen Banerjee, Lordship. On last week, I received their supplementary affidavit, Lordship. But Lordship, I have to take further instruction from department, but on the basis of the supplementary affidavit, Lordship. If your Lordship kindly keep it on next week, so Lordship, I can.
My lord, if your lordship kindly consider the last order, it is the supplementary affidavit has been filed at their request. Why, my lord? May I tell your lordship? My lord, this is a final decree has been passed by this honorable court in a partition administration suit. There, my lord, a specific observation made by the honorable court that the subject matter of the property in the partition administration suit, the partition is not possible. So that property is impartible, and the declaration was made.
They want you to pay stamp duty on an impartible property.
My lord, we raised an objection against their assessment of the Calcutta collector. They are saying that no, you have to pay the stamp duty. We said the stamp duty for on the sale of the plaintiff's shares to the defendant, that we have done. And the another thing is this: since the shares has been declared among the co-sharers, so you have to pay the stamp duty for the partition. Then I raised the objection by saying that I already paid the stamp duty on the sale instrument that has been recorded in the final decree. And so far as final decree is,
The share declared?
my lord, the share declared the existing co-owners.
Declared by the court or by instrument?
No, it is existing co-sharers. Oh, I mean the shares that has been recorded.
The partition was done by way of an instrument of partition?
No, partition was not done, my lord. Partition was not done. Shares of the parties that has been existing, that was just declared. That was recorded. That was recorded in the not declared. That was recorded in the final decree. Final decree. And the final decree, my lord, final decree in the partition administration suit.
So there was a suit for partition.
Lordship. Partition administration suit, there is a preliminary degree accepting the shares of the co-sharer, and thereafter the final degree was passed by observing that this very old dilapidated conditions building, the partition is not possible pursuant to the surveyor's.
What is the state saying?
states first given assessment order, and thereafter a revision. We raised an objection by saying that we have already paid sale duty, but they didn't hear to that. Thereafter, after filing the writ application, when we served the copy of that,
There is a creation of new right or interest in the property.
yes,
The right was already created on the date they purchased the property. Now it's only a question of bifurcation now or distribution. So there is no new right created.
new right created, and the final degree cannot be treated as a partition instrument of partition. That I have raised objections and argued emphatically before the collector. But
Mr. Banerjee, when can he come?
Lordship, kindly keep it on next week,
There
Lordship.
the supplementary.
my lord, the supplementary at their request, my lord, I have bring on record the subsequent assessment order, and thereafter the partition plan, what have been drawn by the partition of commissioner, and the engineer surveyor's report, by saying that the partition is not possible, and that was recorded in the final degree. And I said, I emphatically argued.
Doesn't appear that because stamp duty is payable only on creation of rights.
Correct.
Or title with respect to a property. Title they had by
Correct,
dint of
correct,
sale.
correct.
Maybe undivided. Division of it. That did not create any title. It only defined the title.
Correct.
So why stamp duty? Double payment will be there.
Jeopardy, double jeopardy.
Eligible to double stamp.
My lord, these assessment, lordship, these assess.
For the senior is not there.
Lordship.
As supplementary affidavit filed on behalf of supplementary affidavit filed on behalf
interim order, the department was directed to produce relevant records or instructions with regard to the payment of the TDS along with the interest.
somebody has to appear.
Yes. In other matters,
Your Lordship, item number 7 is the leading matter, that is the company, and 13, 14, and 15 are the directors and employees of the company.
7 is the main matter.
Yes.
To order the court.
Your Lordship, the interim order may be extended.
End of December.
Yes, it is.
It's there. Mr. Sharma, standing counsel for the deputy submits
I am for the customs department. There is a illegal import of smuggling of betel nuts.
They had appeared on the last occasion.
Last occasion, long ago, these matters had come.
For item number 10, Your Lordship, we have sought for some instructions from the client which are forthcoming, Your Lordship. I was praying for a week's adjournment, Your Lordship. By next week, hopefully, we'll receive the instructions.
Instructions.
Further additional instructions, my lord.
Material instructions,
Material
I believe.
instructions, crucial instructions which are
No,
material.
my lord will understand these are betel nut smugglers. So material instructions are very important, particularly when trade companies.
Advocate appearing for the petitioner.
My lord kindly takes it after 24th.
Very good.
Because since I am a little-
adjournment.
20 after 25th.
Advocate appearing for the petitioner.
T3 is a matter of Mr. Subhas Agrawal. He is out of station for 2 weeks for his wife medical purpose. So kindly pick these three matters after 2 weeks. 11, 18 and 33.
I'm appearing in all.
11, 18 and Didi. 11, 18 and 33. একটাই order হবে মানে আলাদা হ্যাঁ 11, 18, 33.
Item number 30.
Your Lordship, I am appearing for the petitioner. In item number 13, 14, and 15, also there were similar orders based on the main matter. And the other side was asked to produce relevant records or instructions.
This item 7 is heard, 13, 14, 15 cannot be.
Pilot is similar order. It is not that these orders are dependent on that.
So they can be heard separately.
Your Lordship,
Some will be the same for all the matters.
Your Lordship, if the company has already paid the TDS along with the interest, how can the director or the independent director or any other employee of the company be prejudiced?
Very well. Then I am directing these matters also to appear along with that matter on.
But Malan here TDS. TDS is here in trust. It is not a property of the. If TDS is not deposited within the stipulated time, So contravention in criminal parlance, my lord, it's a criminal breach of trust.
Your Lordship, but there are judgments that we will cite.
I also did a suit a judgment when the court has refused to interfere.
What should I do? Should I take up this matter now or?
Your Lordship may keep it for Your Lordship may keep it for hearing since my senior will be arguing. I do not have the instructions to argue the matter.
And I will take this on behalf of the petitioner. Same order. And that is why I asked you to
separate orders.
Yes,
Yes.
separate orders.
Wait.
Item number 17.
In this,
Milord,
the
in this
challenge,
matter, Milord,
why
I have,
this has been challenged?
I have challenged the constitutional validity of section 142(11) subclause C of the GST Act. Milord, I have already served. Milord, may I only indicate to your Lordship, Milord? Initially I served, Milord, but my Lord Justice Chaudhuri was.
From the Attorney General.
Yes, Milord. Initially I served, Milord. If your Lordship kindly sees, Milord, initially I had served. But the earlier court, Milord, Honorable Justice Vasu Chaudhuri was pleased to state in his order, observe in his order, that except the respondent number 1, you serve once again. Milord, that exercise I have completed. Only thing, Milord, the service to the Attorney General, it is showing, কি বলেছে? Field service? Article not booked or posted.
Sorry, sir. Not good, sir.
Served, it has to be served again.
Otherwise, other respondents have served. But
No, if you are not going with the virus challenge,
then I am
then
definitely going.
you is
Then
going
the
with
Attorney General has to be. It appears
but
that service upon the
For the customs.
wonderful. It's in your case.
We take
What has been challenged here? Order in original.
Original.
Ground.
Grounds, my lord, violation of natural justice and other related issues.
Jurisdiction.
None appears for the petitioner. Full stop. None appears for the petitioner. Full stop. No accommodation is prayed for.
Appearing for the respondent. Mr. Jhunjhunwala is appearing in this matter for the petitioner.
Very
My lord, may I, today the matters are taken on this fast, so maybe he has missed. Let him give him opportunity to be given to.
None appears for the petitioner. Full stop. The respondents are represented.
Item number 23. For the petition.
May I file the affidavit of service? We'll come back. Your Lordship, we'll come back tomorrow, Your Lordship. No, Your Lordship, fresh, not.
Item number 24. Item number 24.
Target order for dismissal Calcutta. Not.
Item number 25.
I am for the union.
None appears for the petitioner. The respondents are represented.
Not today.
No.
Your Lordship, item number 29, Your Lordship, Mr. Bhonjo is here. I had mentioned yesterday, Your Lordship, there's an urgency, Your Lordship, if that matter. Because Your Lordship, live consignment.
Lordship, I am led by Mr. Anil Kumar Dugar, 27.
27.
Anil Kumar Dugar, Lordship, in this matter, which one is the refunded amount? We have received the all disputed and refundable amount. So, as per instruction of our client, so Lordship kindly pass necessary order in this regard, and this matter with no Lordship. As per instruction.
Or you have instructions, Mr.
Malad, I have spoken to no, I have nothing in right.
I'll instruct you on record.
Yes.
I don't allow withdrawal like that. You bring a letter tomorrow?
Okay, Lordship. Lordship.
Put it under to be mentioned tomorrow?
Yes, Lordship, yes, Lordship.
Legally. An advocate appearing for the petitioner submits that the I don't know what I have done.
Lordship kept it on the 21st. All these matters, as I said, your Lordship, arising out of the same Lordship, they are on late page, item 30, in footnote 39. No, Lordship, just right now, it's arising out of the same impugned order as I said. The matters are together.
What I have passed, I don't remember that. How can I suddenly change the dates? I don't know who was appealing for the
None have appeared today from the petitioner's side.
You were there?
Yes, your Lordship.
Then why did you not mention?
No, I just went, your Lordship, I got instructions.
Then if you are not there, how did you know nobody had appeared? I cannot change your, I mean, my orders on the basis of whatever is there is there. Or you ensure to be here when the matters are called on. It becomes very difficult. Grateful. Item number 28.
My Lordship, I am led by Miss Anupa Banerjee. Her daughter's medical health is not good. So on that one, praying for not today. Not today. Thank you.
Item number 29. Yes, Mr. Dev.
Your Lordship.
Matter is severely urgent.
Yes.
Your Lordship, the urgency is because the consignment was seized, Your Lordship.
Yes.
Early hearing. Actually, Your Lordship, the petitioner had imported one consignment of second-hand hard disk drives, Your Lordship. Your Lordship, at page 27, Your Lordship will see it's a commercial invoice. Your Lordship, these hard disk hard disk drives are of two brands. One is, Your Lordship would find serial number 1. Your Lordship, it is written WD. WD means Western Digital, Your Lordship. Your Lordship, internal 3.5-inch SATA data storage drive. Then, Your Lordship, there's a number. And then WD. WD is the brand of Western Digital, Your Lordship. And Your Lordship, second number, Your Lordship will find that it is Seagate. Seagate brand. Your Lordship, both these companies had filed trademark cases, Your Lordship, in Delhi High Court. Your Lordship, in one of the cases, I was also a party. Your Lordship, these companies are the manufacturers of hard disk drive. So, Your Lordship, they don't want that second-hand hard disk drives are imported, Your Lordship. It affects their sale directly, Your Lordship. So, Your Lordship, in that, court had asked them if there is any legal impediment in importing hard disk drive, and they had specifically, court had made a finding that there is no legal impediment. I'm relying on that judgment, Your Lordship. 2024, 4 High Court cases, Delhi, page 265. Your Lordship, for convenience, I've just flagged the relevant paragraph. I'm placing it, Your Lordship, and then handed over. Notably, Your Lordship, these goods, Your Lordship, my consignment was seized on 13 June 2025. Your Lordship, the seizure memo is at page 44-45. Your Lordship, they seized the memo, seized the goods. Your Lordship, the only dispute they have raised is whether it is capital goods or not. According to me, Your Lordship, this is not a capital goods. And this is capital goods, and second-hand capital goods other than, Your Lordship, computers which are given is freely importable. Your Lordship, in the seizure memo, Your Lordship, at page 44-45.
Yes.
Your Lordship, if Your Lordship will see page 44, Your Lordship, goods have been found in order in, Your Lordship, there are two charts. So goods have been found in order as per my declaration. There is no dispute. Now, Your Lordship, next page. Your Lordship, paragraph 3, the last 2 lines. The authorized person in his statement has admitted that serial number 1D of para 2.31 of foreign trade policy only allows other second-hand capital goods free for import. So, Your Lordship, it is my contention that it is freely importable, being a capital goods. Your Lordship, capital goods, Your Lordship, no.
It only allows second-hand capital goods and does not allow parts of capital.
Your Lordship, yes. Next, Your Lordship, it is their condition as per serial number 2 of the said para, second-hand goods other than capital goods. So, Your Lordship, the dispute is whether it is other than capital goods or it is second-hand capital goods. Your Lordship, may I hand over a copy of the FT foreign trade policy? Your Lordship, the marked copy only I am handling, Your Lordship, for convenience. It marked copy, Lordship, Your Lordship, all other second-hand capital goods other than ABC free, as per my declaration. And as per the department, Your Lordship, serial number 2, second-hand goods, next page, Your Lordship.
Other than capital goods?
Yes. So, Your Lordship, this is the crux of the dispute. Your Lordship, in two Delhi High Court judgment, Your Lordship, may I just hand over, Your Lordship? Your Lordship, it is specifically, they could not show that there is any impediment in this import. And Your Lordship, in the second judgment, Your Lordship, I was also a party. Your Lordship, both these companies are involved in these two cases, Western Digital as well as Seagate. And Your Lordship, what they have done after this seizure memo, the department is silent. Your Lordship, if my goods, they will say that I can issue show cause in 2 years, but Your Lordship, my goods will lose its value. And Your Lordship, why I say it's capital goods, Your Lordship, it is also covered. Your Lordship, any goods which is not consumable, which has a long use, is capital goods. And Your Lordship, goods which are consumed in a factory, like raw materials which which is immediate. Yes.
Where is this definition given? Capital goods or not capital?
Your Lordship, that definition, Your Lordship, I will, Your Lordship, in the SENVAT credit rules, Your Lordship, SENVAT credit rules of 2004, Your Lordship, it was specifically said that all goods falling under Chapter 84, Your Lordship, is capital goods. Your Lordship, although my goods are also falling under Chapter 84. May I, for convenience, Your Lordship, just mark the Chapter 84, Your Lordship. Your Lordship, there is a judgment of
So according to you, your goods are capital goods?
Your Lordship.
They are free for import?
Your Lordship. And Your Lordship, they have, after this seizure in June, kept silent. Your Lordship, they have not issued any show cause. Your Lordship, they may decide this in a time-bound manner, Your Lordship. Your Lordship, under Section 47, they can make a final assessment. And Your Lordship, I had made, before this import, I had written to DGFT. Because if it is not capital goods, then all I need, Your Lordship would see that serial number 2, all I need is a permission from DGFT. I had written to DGFT before this import. They were silent. Even after the import I have written, they are silent. And Your Lordship, I have asked them for provisional release earlier. They had not given. So Your Lordship, now I am saying let them decide, issue a show cause, decide in a time-bound manner, or decide as per Section 47, whatever they have to do, Your Lordship. All I want is my consignment should be, Your Lordship, the fate should be decided.
After the decision, whatever fate the consignment.
Your Lordship. And Your Lordship, in a time-bound manner, Your Lordship.
Lordship, law gives us 6 months time to issue the show cause notice after seizure. So we are well within the time period.
Your Lordship, 2 years for adjudication.
The law purpose says that I can pay for further extension of 6 months time. So therefore, I am well within my statutory time limit to issue my show cause notice. My lord, the entire exercise is at a very nascent stages. We have issued summons and all the formalities are being carried out. So, my lord, Lordship, can you give us some time so that we can carry forward with our investigation and conclude the investigation? And thereafter,
what are the timelines?
6 months and 6 months. If your Lordship kindly sees Section
That
110,
shows, Your Lordship.
read
And
Section
2
1.
years is for adjudication, Your Lordship. Your Lordship, this is the entire exercise is to make
under
my
Section 124 subject to correction. There is no time constraint. There is no time constraint. Time constraint is there for adjudication under Section 28. And this is by the tenor of the investigation that is going on so far, though we have not issued the show cause notice. Probably a show cause notice under Section 124 is appropriate.
Your Lordship, let them disclose what investigation they have
No,
done.
I
in the
cannot
June,
disclose
Your
the
Lordship.
investigation as you
Your
say.
Lordship, court
They are
is
not
not
entitled.
Your Lordship, the entire attempt is to make this, Your Lordship, frustrate
And
this.
moreover, my lord, it's a case of a rampant misdeclaration, which is apparent from the seizure memo itself. If your Lordship sees section, page 44, what they have declared and what has been found upon examination.
Yes.
Lordship kindly sees page 44, declared goods, internal 3.5 inch SATA data storage drive. And what is found is desktop 3.5 inches, SATA HDD W8 such and such. So completely different materials.
Second hand.
And these are all second-hand materials which are restricted as per foreign trade policies.
Restricted not by.
Your Lordship, it is not even restricted.
Subject to condition.
Your Lordship, they have done nothing after the seizure memo. For 4 months, they have not disclosed anything they have done.
Whatever are the steps that we have taken during the course of investigation, is we are not bound to disclose it to the petition.
Section 100.
Yes, Lordship, kindly see section 110.
Yes.
Lordship, kindly see section 110 subsection 1. If the proper officer has reason to believe that any goods are liable to confiscation under this act, he may seize such goods. So under this provision, one of the goods have been seized because these goods are ultimately liable for confiscation upon issuance of a show cause notice.
Yes.
Now, Lordship, kindly comes to subsection 2, 110, subsection 2.
Yes.
Where any goods are seized under subsection 1 and no notice in respect thereof is given under clause A of section 124, within 6 months of the seizure of the goods shall be returned to the person from whose possession they were seized. So therefore, my law is giving me 6 months time to carry out investigation and to issue the show cause notice. Now again, Lordship, kindly see the proviso. Provided that the principal commissioner of customs or commissioner of customs may, for reasons to be recorded in writing, extend such period to a further period not exceeding 6 months and inform the person from whom such goods were seized before the expiry of the period specified. So therefore, I am getting 6 months time, which is further extendable by another 6 months time. And these goods have been seized on 13/6/2025. So I am well within the first 6 months time.
Your Lordship, this is not a prohibited good. Your Lordship would kindly take section 47 also, Your Lordship.
That question will be settled only after adjudication, whether it's a prohibited goods, whether it's a restricted goods or not.
This is premature for this court to.
Your Lordship, why? This is not prohibited goods. According to them also, Your Lordship, there is only a restriction that we need permission from DGFT. I have before import written, Your
Yes,
Lordship.
Mr. Deshi is correct in that, because the only distinction which the seizure memo does is as to whether it is restricted or whether it is free. Because if you see your seizure memo.
Yes, madam.
Uh, 45.
Yes, madam.
The last 3 lines which were the authorized person in his statement has admitted that serial number 1 of para 2.31 of the foreign trade policy allows the other second-hand capital for export, and the said serial number does not allow parts of capital goods for export. As per serial number 2 of the said para, second-hand goods other than capital goods can be imported against authorization.
So, Your Lordship,
thus import of second-hand HDB restricted for import as per FT. It is not prohibited.
So it's restricted with certain other conditions. So therefore, it has to be seen whether those conditions have been complied with or not, which is a subject matter of show cause followed by adjudication.
Your Lordship, under the foreign trade policy, DGFT is the authority who is supposed to give, if it is restricted, that permission.
If the statute gives them 6 months, how can I hush them up?
Your Lordship, Your Lordship, first of all, if DGFT is the proper authority, Your Lordship, kindly take page 46.
These are not perishable goods that they will perish. Even if they were, the statute states
Your Lordship,
after 6 months, if they cannot give, and if there is no extension, they will
Your Lordship, today there is no. Your Lordship, today there is no show cause. Your Lordship, we don't know under what provision they will proceed.
Today, we can't say that there is no show cause because the time for show cause is still there.
Your Lordship, section 47 also, Your Lordship.
Section 47 says what?
Your Lordship, it says clearance of goods for home consumption.
But this is not for home consumption.
Your Lordship, yes, home consumption. It will be utilized here. It is whenever it crosses the custom barrier, Your Lordship, it will be for home consumption.
Show section 46, which provision?
47, Your Lordship. Where the proper officer is satisfied that any goods entered for home consumption are not prohibited goods, and the importer has paid the import duty, if any, assessed thereon.
Satisfaction of the proper officer be obtained. if the proper officer is satisfied, this satisfaction, can it be done at the Caesar?
On
level?
duty
Yes.
only, your lordship.
This satisfaction has to be reached by a way known to law.
Your
That-
lordship.
That is a way of adjudication. only.
Your lordship,
If-
100 and
And this has to be read with section 46 subsection 4, because law cast a statute upon them, a obligation upon them, come up with truthful statement. and
Your lordship,
truthful
where is the
disclosure.
misdeclaration?
But
Your
it's-
lordship,
It's an absolute misdeclaration which is patent on the face of it.
Your lordship-
Lordship, kindly see section 46 subsection 4. The importer, while presenting a bill of entry, shall make and subscribe to a declaration as to the truth of the contents of such bill of entry, and shall, in support of such declaration, produce to the proper officer the invoice, if any, and such other documents relating to the imported goods as may be prescribed. So therefore, 47 cannot
Your
be read
lordship,
in an
there
isolated
is-
manner. It has to be, it is, terms of section 47 is circumscribed by the conditions of section 46 subsection 4.
Your lordship, one more provision, your lordship, there is a provision for provisional release also, under 110A, your lordship. 10A. Your lordship, here there is, your lordship, it is very clear that the dispute is not of misdeclaration. It is, according to them, your lordship, the dispute is whether it is a capital goods or not.
It is not prohibited.
And your lordship, the goods are not prohibited. Your lordship, and as per section 25, your lordship, 125, even if it was prohibited goods, it can be released in lieu of fine, penalty, etc. So, your lordship, there is no impediment in releasing these goods provisionally.
But this 100A is subject to taking bond.
Yes, your lordship. Bond. So, your lordship,
With
these.
such security.
Not only
and
bond,
conditions.
security.
Yes.
Security.
So, your lordship, whatever the
And for
duty.
that, they have to make an appropriate application.
I have, your lordship,
because
I
the
have.
appropriate forum.
I have, your lordship. I made an application long back, your lordship. My letter for
But you have
provisional
made
release is.
that application.
Yes, your lordship. At
Where?
page 63, your lordship.
Page 63.
3, your lordship. After that, they have kept silent, your lordship.
We consider and dispose of this application.
Very
Mr. Dave.
As per
That
law.
will serve the purpose.
As per law.
That will serve the purpose. Instead of me entering into all this, we have made the application, they'll consider it in terms of section 110A.
Your lordship, in a time-bound manner, your lordship.
This application definitely in a time-bound manner, because Mr. They can't say this will be done in 6 months.
No.
Yes.
rising. Today morning we have mentioned the matter. Well, we have already served the notice.
My files are there. There is this.
I have checked the file. I have checked the files.
দিদি ম্যাটার গুলো একটু নিয়ে আসবেন চেম্বারে যেগুলো আর্জেন্ট আছে সেগুলো একটু একটা অ্যাপ্রোপ্রিয়েট লিখিত করে
Lordship, before Lordship rises, Lordship's item number 20 and item number 25 of today's list, Lordship. Lordship, I have been told there were two other items, 19 and 24. Your Lordship was pleased to fix the matter on 21st.
See, actually, I don't know on which date I have fixed which item. So
On the
now
21st November, Lordship.
I don't remember because different dates were given for different items. Your item was there, thereafter there were other items also. I don't remember today, the other side is not there. I'll start fixing dates. It will be arbitrary when the matter come in the list. You can accordingly fix it.
Lordship.
Yes, yes, definitely. Then I'll be able to review it. Yes.
Some of the matters that I cannot write.
Yes, yes. Several matters are there.
Yes, ma'am.
On the 21st of November, would it please your Lordship to fix these two matters on the same date as well?
Let them appear in the list on the day when I have directed, because I do not know which steno took the direction.
Great.
If somebody else has taken it.
We'll do, Lordship.
It's difficult.
We'll do, Lordship. Great.
Because I have not dismissed, I have not passed any adverse order if it is appearing in the list.
Lordship.
That is the
Lordship.
difficulty that you will be facing on that day.
Lordship.
To come before this court again. That's
It's a pleasure, Lordship.